Afternoon. I would like to call the meeting of the California Board of Accountancy to order. Today is November 17th. I would like to go ahead and begin with a roll call. If we could start at this end.
Mary Ann Hines.
George Familette.
Larry Capital.
Leslie Romano.
Katrina Salazar.
Alicia Burhow.
Jose Campos.
Kathleen Wright.
Deirdre Robinson.
Sochi Leon.
Mark Silverman.
Thank you. With that, we do have the establishment of a quorum. I would like to open the meeting with a remark to remind our participants and our listeners that the mission of this board is to protect consumers, and it does that by ensuring only qualified licensees practice public accountancy in accordance with established professional standards. So this mission is derived from the statutory requirement that the protection of the public shall be the highest priority for the California Board of Accountancy in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. So thank you for that, sharing with me that reminder. To those here, I would also like to point out that we have initiated the use of tablets, so you will see some tablet devices around the table, and that is being used by our participants to access the materials as they are participating. And lastly, it is a little bit difficult to hear, so we do have microphones. If you do not have one directly in front of you, please pull it towards you yourself when you speak. So I do want to acknowledge that this meeting is starting slightly later than scheduled, and that is because we had productive discussions happening at our committee levels. But because of this change, what I would like to do, since it is lunchtime and we have called the meeting to order, we will go ahead and break now for the lunch, and we will resume at 1:05, which gives us 1 hour. And we will then resume with the items in today's board meeting. Thank you. Meeting recessed. Wonderful. Thank you and welcome back. I would like to resume the California Board of Accountancy meeting. Today is November 17th. The first item on the board today, I'm Katrina Salazar, and that is the President's report, so I will go ahead and give that. The very first item, A, is a resolution for former Board of Accountancy member Herschel Elkins, and it is being considered to be granted posthumously, so I would like to take the time to read it into the record. His contributions have been significant over the years. And it reads, whereas Herschel T. Elkins, Esquire, was appointed to the Senate Rules Committee, and he has faithfully served as a board member of the California Board of Accountancy from September 19th, 2008 through September 5th, 2016. And whereas he served as chair and member of the Enforcement Program Oversight Committee, member of the Committee on Professional Conduct and Legislative Committee, and as liaison to the Enforcement Advisory Committee. And whereas throughout his term of service, at all times, Herschel T. Elkins, Esquire, gave fully of himself and his ideas and acted forthrightly and conscientiously, always with the public interest and welfare in mind. And whereas Herschel T. Elkins, Esquire, previously served as Special Assistant Attorney General for Consumer Policy, Coordination and Development in California, and as an attorney in the Attorney General's office. And whereas he has held leadership roles in civic organizations, including the statewide head of Attorney General Consumers Law, statewide head of the Attorney General's Consumer Law Section, the first chair of the California State Bar's Consumer Finance Committee, and past chair of the California District Attorneys Association Consumer Protection Committee. Now therefore let it be resolved that the members of the California Board of Accountancy express heartfelt appreciation for the outstanding contribution Herschel T. Elkins, Esquire has made during his term of service on the California Board of Accountancy and to the consumers of California. So with that, I'd like to put forward a motion for this board to approve the resolution just read into the record for Herschel T. Elkins. May I have a second? Second. I'm going to give that, sorry, we had a very quiet hand raise, so the second goes to Mr. Silverman. Member comments? All right, public comments? So with that, I'd like to please call for the vote.
Okay, Alicia Burhell,
Yes.
Jose Campos. George Familet,
Yes.
Carrie Ann Farrell Hines,
Yes.
Larry Kaplan,
Yes.
Leslie Lamana,
Yes.
Soshi Leon,
Yes.
Jin Uyang,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar,
Yes.
Mark Silverman,
Yes.
and Kathleen Wright.
Yes.
Thank you. With that, the motion passes. I would also like to acknowledge that we have received a resolution that has been granted by the California Senate, also to Herschel Elkins, and that this will be forwarded along to his family, but it will be available for the folks in attendance today to look at, as well as the board members before it is sent. So again, thank you very much for your recognition. That concludes item A. This second item is a report on the National Association of State Boards of Accountancy annual meeting. And I will share that I was really honored to represent California at NASBA's 109th annual meeting. This year it was held in Austin, Texas, and it began on October 30th and went through November 2nd. It was notable in that every state and jurisdiction was represented at this meeting. So I believe the number was that there were 414 regulators of accountants gathered in one place. And so it was a great opportunity to hear what is happening at a national level. I was invited to speak and did co-present to the full body along with NASBA's Regulatory Affairs Manager, Stacy Grooms, who has presented here in front of this body as well. And I spoke on the mobility issues and shared an update on the progress of the mobility stakeholders group and where we are with her mobility timetable. There were a lot of topics covered. Accreditation quality was discussed, which will be on our agenda a little bit later today. I will note that several of the highlighted legal cases in the presentations involved cases related to California. And it's important to note NASBA is working on language for states that wish to recognize management credentials, such as the CGMA. So there are a lot of topics being discussed, and the North Carolina issues, which our council will be updating us on, is also being discussed at a national level. So there is a group called the Professional Licensing Coalition Initiative that is also trying to tackle that issue, and NASBA has been communicating their progress through their meetings. And of course, there was quite a bit of discussion about CPE standards, which is something, if you were listening to our committee meetings, we are also discussing. So with that really concludes a very brief summary that I have for you on the annual meeting. And I'd like to move on to the next item and invite Mr. Ed Joliker up to the table and introduce him. The item C is his report, and as he's getting himself settled, I would like to share he's here to talk about the NASBA, or actually NASBA, but you know, he has some pretty great credentials. So Ed, if you don't mind me embarrassing you a little bit, I would like to share that Ed is currently the Pacific Regional Director and Chair of the NASBA's Bylaw Committee, and he is on the NASBA's Relations with Member Boards Committee, and has a deep wealth of experience both with NASBA committees as well as AICPA committees, and as a former member of the FASB's Income Tax Accounting Implementation Group. So with that, I'd like to invite Mr. Joliker to address the board and share some of his observations about NASBA and give us an update.
Great. Thanks, Katrina. It's really my delight to be here. I've been a regional director for the Pacific region for 2 years. I'm starting my 3rd year right now, and I apologize that I haven't been able to get here prior to this. It's just my goal is to get everywhere to all 8 of the boards. Probably won't do some of them because a couple of the boards are actually Pacific region includes, of course, the coastal states, including Alaska, of course, and then also Arizona, but also Hawaii, Guam, and CNMI, which the chore of getting out that direction is significant and costly, of course. But anyway, my goal is to get around and see at least the boards at least once during my term, and this is my at least one time. Hopefully, this won't be the end of it. As Katrina said, I've been involved in NASBA for a long time, and really I was on the Washington State Board for 11 years. That's when I first started getting involved in NASBA and on committees and that kind of thing. And I chaired the Washington State Board for two separate terms, and I just recently rolled off the Washington Board. So it was great service, great experience, and I really want to compliment this board for what I've seen so far, and of course what I know from talking to Jose and Katrina and others, how hard you work. It's no small matter that you're investing time beyond just the meeting to get things done, and I really want to compliment the effort and the quality of the boards and its committees. I'm also a retired CPA, retired partner from the firm Clifton Larson Allen in Spokane, Washington. That was our office there that I was partnering. So, my role as a Pacific Region Director is to provide a number of things, one of which is a connection between the state boards in our region and the board of directors of NASBO. Of course, I sit on that board, so the idea is that we can have a close relationship, and when issues come up that concern you, that you have a way to get them to the board. We can get them on our agenda if it's deemed appropriate on a national level. Also provide some communication from amongst the region, and also from the board back to the regions, or back to the boards, as well as provide input from you to the board and other NASBA groups. I'm an additional NASBA resource, and you've seen, of course, Stacy Grooms, who does a fantastic job in my view, and I don't know if you've seen Dan Dustin, who's our VP of State Board Relations, and John Johnson, who does legislative. A lot of other folks, Maria Caldwell, those are all staff people who work very hard on all states' behalf. But I'm a volunteer like you are, and my goal is to really provide just that additional resource and different perspective. Also, the regional directors run the regional meetings, which are held in June every year, and I know last year a number of you were able to attend the meeting, the regional meeting down in Coronado, which was, I think, a very well received, as well as the annual meeting, which was in south of LA. I forget the name of the town, but it was it was great, and I know you have challenges getting outside of the state, and hopefully you can attend future regional meetings. The next one being in Coeur d'Alene, Idaho, which is very close to where I live in Spokane. That's in June 6th through 8th, coming up next summer. So. I also do conference calls twice a year with board chairs and executive directors, staff. We do breakout sessions at the regional meetings. I'll mention briefly a little bit later what some of the issues were that we discussed in our breakout session that we just had in Austin. And, of course, visits to state boards. So that's kind of the broad purpose of what a regional director is. There are 8 regions throughout the country, and like I say, I'm the Pacific region is just one of those. So at the NASBA board meeting that was held just prior to the annual meeting in Austin that Katrina referred to, the board voted on a couple of issues that they were mentioned briefly and at the annual meeting, and I want to just mention what they were. First, we voted to approve a unilateral pathway for international candidates as a pathway to become CPAs in the United States. You might be aware of the mutual recognition agreements that we have. There are 6 of them right now. One of those includes Mexico, which I think is particularly relevant to this state, and of course Canada and a few others. Those recognition agreements are kind of a quid pro quo. That is, we will recognize those international candidates who are, if they're qualified, to come in and become licensed in the United States without taking the CPA exam. They have to take what's called IQEX, or the International Qualification Examination. If our candidates in those countries can similarly become licensed in that jurisdiction, if we have a CPA who wants to be licensed in Mexico, Canada, whatever, in one of those 6 countries. So, in other words, it's bilateral. We've decided to expand that to a unilateral arrangement in which we will allow international candidates, of course each state has to decide this, but international candidates can meet our licensing objectives in the United States if they are from a jurisdiction that has the 3 E's: education, experience, examination, if they're qualified, if they can sign audit reports, that kind of thing. So countries like Germany that has, I think it's 9 years prior to becoming a qualified accountant to sign reports, those individuals would be qualified to take the IQEX in the United States and become licensed as a CPA. The goal is ultimately to have a mutual recognition agreement with those countries. But we understand that it's just very difficult for countries like South Africa, Germany, and others that have substantially higher requirements to become licensed and sign reports than we do in the United States. So we're using this as a way to sort of provide a mechanism and a way for those individuals to come in, and hopefully for the U.S. individuals to become licensed in those jurisdictions as well down the road. And if the MRAs do not result out of those, then the NASBA can revoke that unilateral agreement with that country. So again, it's only certain countries that where we feel the equivalency is appropriate with the United States. And some people might ask why we're doing that. And one of the, apart from trying to allow greater interchange internationally, recognize that we're an international economy, the idea is there are those people from outside the U.S., those qualified credential holders from other countries that are practicing in the country right now, in the United States. And they're really not under the state board's jurisdiction at this point. So providing a mechanism for them to become licensed and under our jurisdiction serves the public and also provides the kinds of benefits as I referred to earlier. So that's kind of what we're looking at. And by the way, if there's any questions on any of these, please jump in anytime. The other thing we voted on to approve are the model rules for the CPA exam, and I know you're all over that. Just wanted you to be aware that the board of directors of NASBA did approve the model rules. I'd like to talk about a few trending issues that were discussed at the annual meeting as well as the board meeting, some of which were already discussed in some of the committee meetings here that I attended this morning. The first issue is use of title. And as Katrina mentioned, there was a big discussion relating to management accounting titles and credentials, whether it be CGMA or others such as CMA, which is issued by the Institute of Management Accountants. There's, I guess, a concern that not only at NASBA level, but a number of boards have concerns about misleading and confusing title usage for non-CPAs. As a matter of fact, this week I got a copy from NASBA of a letter that went out to, I guess, state CPA societies from an, excuse me, from an organization called the International Institute of Professional Accountants, IICPA. Certified Professional Accountants, I'm sorry. International Institute of Certified Professional Accountants. And there's a brother-sister organization called the International Institute of Certified Public Accountants. That's in the U.S. This other organization, the international one, is Professional Accountants, is presumably based in Switzerland. They are, they're saying that membership is open to, and credentials are available to CPAs, former CPAs, enrolled agents, tax accountants, management accountants, etc. So this is, again, this is a credential that we feel, that NASBA feels that it could provide a real risk to the public of misleading and misunderstanding and a confusion of titles. So that's just one example. I would hazard to guess there may be more in what some might call cascading effect, and I might call it a mudslide of titles that could come out of the woodwork over the next few years. And the idea is that we feel that most, or maybe all states, have the laws on their books, their statutes and regulations that prohibit confusing, misleading titles. Some of which is either directly out of Section 14 of the Uniform Accountancy Act or the state's various versions of that. And it's really up to the states to enforce that. We really feel strongly that states need to enforce it, because if you don't enforce it on one title, another title and yet another and another may be coming in, that it will be very difficult to enforce it against. And again, all in the context of protecting the public. And we really feel that it's important that states do enforce that. There may be states that wish to allow a management accounting title for a non-CPA. And if that is the case, then NASBA is working on model language that would provide states the kind of safeguards for the public if the state wishes to have that kind of a title in the state. I think it's if the state chooses not to enforce its ban on a title, or the language relating to confusing and misleading titles, if they choose not to enforce that, then I think that's a much bigger risk than at least implementing language that would allow it. NASBA is really not going to advocate that states adopt language to allow it. However, some states have said they want to. So we're going to provide that. That'll be out, probably right now it's at the UAA committee, and I would say sometime next year it'll be available and probably will be rolled out at the regional meeting in June. Okay, let me move on to a couple of other topics. Evolution of peer review administration, and this is one that's really not that relevant to this state, since your state society, the Cal Society, is the administrative entity for the CPA, for the peer review program for the CPA, and it's going to continue, and I know you administer some other states and may take on even more. I'm not sure that the society would. So there was a white paper, which I'm not sure if this board reported on it or commented on it, that NASBA did and a number of other states did. And there was a lot of concern among various states who are going to lose their administering entity status. So there were a lot of comments on that, and they're going to reissue and revise significantly the proposal to consolidate administering entities. And that reports, or that white paper revisions coming out in January, I believe, for a 60-day comment period. So I encourage you to take a look at that. One of the concerns we have at NASBA relating to peer review administration is the fact that the oversight, which I know this state has a very effective oversight committee, and a number of states do, real concern about when a state loses its administrative entity, how is that oversight going to take place, what's it going to look like. Another topic that was discussed both at the board meeting and the annual meeting was the accreditation of accounting educators, educational institutions, I should say. And there's a project that's underway right now headed by Dr. Jan Williams. And, you know, some of the concerns that they have raised and we're looking at is, okay, state boards are relying on accrediting organizations that the candidates that are going to those schools are qualified, that they're going to meet one of the 3 E's, right, the education side. And if we're relying on the accreditors to be satisfied that the quality of those graduates is there and their programs are there, then we want to know what was involved in the accrediting process and have they considered all the factors. In particular, concerns that have been raised relate to competency-based credit. I'd call it test-based credit. Credit for work experience, credit for life experience, credit for review of CPA exam materials, cram courses, international credit transfer practices, and the expansion, the significant expansion in cooperative and internship programs for credit. The other area that they're looking at, or one other area they're looking at, they're spending a fair amount of time on, is that I'm not sure what California requires, but for example, Washington accepts just regional accreditors. Regional accreditation of an institution is accepted in our state without any further review or consideration or evaluation. And regional accreditation only is at the institutional level. It is not at the let's say the accounting school, business school, whatever level. Those are program accreditations, and many states do not require accreditation of those programs, which I think is significant to our interest as regulators. So they're looking at that area as well. More to come on that. Last item there was a kind of a hot button was use of data analytics or big data. That's a new project that is being started, and the goal there is to provide state boards with resources and capacity or capabilities to evaluate cases in which data analytics are being used as a substantial audit tool. And that the audit rules or the audit practices, I should say, are changing rapidly. The audit standards really haven't kept up. I know that. I was on the Auditing Standards Board for a few years, and there's a pretty long window prior to getting things done there, I can assure you, but there's a project that they have on that right now, but the standards right now are not up to date to deal with data analytics. And the problem we'll run into is if a state board, now California has substantial resources and capabilities. Many states do not have anything near what the state has. And when you run into a substantial case of alleged audit failure where you have some very sophisticated audit tools like data analytics being used, it's going to be difficult for boards and their staffs to address that. So NASBA's working on that area to expand resources. Okay, just other topics, just real briefly. I apologize, I don't want to ramble on. I know you're short of time. The California Enforcement Initiative, of course, Katrina presented, and by the way, it was very well received. Really did a great job and really we really appreciate the effort both at the regional meeting and the annual meeting to do that. We, as you heard earlier in one of the committees, there are now 45 jurisdictions that are substantially equivalent. They have the online enforcement flags, which is really critical. 10 more are in process, and NASBA is committed that those 10 will be in compliance prior to your, I think it's July 17th deadline, if I'm not, it's either, whatever that deadline is, NASBA is committed to meet. So we're really happy that that'll happen, and honestly, as I told Jose earlier, we're really pleased that this issue has come up because it made a lot of states, including NASBA itself, take a hard look at what are we doing nationally, and are we really doing what we say we're doing? And are we going to protect the public appropriately, provide those mechanisms for users to understand whether you got a bad actor out there or not. Firm mobility. There are, just to let you know, there are now 16 states that have enacted firm mobility. Some of those states, most of them, already had it in their laws and regulations. Washington and Indiana this past year passed firm mobility, and Illinois is coming up very soon. And the CPE model rules are going to be out. They're being worked on right now. They should be out, I think, before April or by April of next year. And also the CPE audit tool, which has been promised for a long time, will be out by April of this coming year. It's a very substantial IT project at NASBA and should be a great resource for states that want to use that. So let me just mention just briefly the breakout session topics, as I promised Katrina I would. When we had a breakout session, each region has their own separate session, and Pacific region, we had all 8 of our jurisdictions were there, and we have whoever was there from the board and the staff. We didn't have state society or other guests at those sessions. The topics that were discussed primarily were the AICP's proposal for peer review administration, practice continuation, for situations where, particularly sole practitioners and very small firms, where in some cases in Washington, client records have been left out on a street corner when a practitioner passes away or leaves unexpectedly. So that was a hot topic. Outreach to colleges and universities, the pipeline issue to add more students and those to get involved and interested in public accounting and becoming a licensee. What some states are doing to improve that. We spent a fair amount of time talking about CP rules and nano learning and those things that were talked about earlier in one of the committees, and what some states are going to have to do to change their rules. And the use of title topic, again, was probably the #1 item that we spent time on. So those are the main items that we talked about in the breakout session. It was good information, and we use that information really to build our agenda to help state boards, and I take that back to the board of directors at NASBA and our relations with member firms or member states committees to decide what we want to do to set our agenda going forward. So with that, I guess I'll stop, and if there's any questions, happy to field them. And yes.
Just a quick point of clarification. You mentioned that, or I understood that today there might be CPAs or accountants who are from overseas that are practicing in the United States, but they're not within the jurisdiction of states.
Correct. They're not licensed in the United States. They're not CPAs. So they would be a chartered accountant from England,
Okay.
or I'm not sure if they're CPAs or whatever the title is in Germany, working here for their firms. No, they're not holding out as a CPA. They're probably, I'm assuming that, or from Canada. Well, Canada's got the MRA, but they're working in the United States without being a CPA. And I'm saying that if they are a CPA, states would have, just like our CPAs in California right now, you have jurisdiction over them. If they're not a CPA, you really don't have any direct jurisdiction, at least. Did I?
Yeah, I'm just trying to figure out that from the eyes of the consumer, they look like a CPA, but they're not a,
They're reporting, they're providing services, and they're issuing reports, but their signature won't say CPA, but that would be the concern, I think, and this.
Yeah,
this
they shouldn't
could-
be issuing reports
And
as a
as
CPA.
we can certainly, I will just say, we can absolutely ask clarifying questions, but we do want to avoid discussions, because we can agendize future items. But I think in terms of clarifying your statement, I think we're good.
thank you.
Did you have?
I can ask them if I'm not allowed to ask it, then let me know. So, but does NASBA monitor these chartered accountants from overseas at all?
No.
Okay.
You know, NASBA is an organization, you know, our mission is to enhance the effectiveness and advance the common interests of state boards. That's our mission. And we're a nonprofit organization, we're not a regulator. We provide resources. The membership of NASBA consists of each state, each jurisdiction's state boards. That's our membership. So we don't really have authority, or, you know, that's not our charge, if you will, but we know what's going on.
Okay, good to know.
We hear about it from our states, and our goal is to try to help them deal with it. And this is just one way that we're trying to improve that.
Thank you. Well, and thank you so much for taking the time to come here to address our board. And it's very timely because we did just have the annual meeting, and I will share with you, they are long days. They start very early. There were 3+ days, and even that brief summary really just starts to touch upon the things that this board may be putting on agendas and issues coming down the road. So it is a very helpful thing to have you here to kind of share some of that information. So
I'm sorry, can I just interject? If anyone is interested in anything that happened at the board meeting, or I'm sorry, at the annual meeting, there are videotaped, or they're videoed, and there is an archive. I don't know if it's been released yet, but that archive will be available on NASBA.org. So you could look at any of the sessions, including Katrina's presentation with Stacy, and it was, you know, if you have an interest
gee,
in
thanks for that.
Yeah.
But thank you for reminding us.
Thank
And that agenda of those sessions is available online as well. So again, thank you so much.
Thank you. It's my
for
pleasure.
coming here. Okay. So that concludes item C. Moving on to D is the 2017 California Board of Accountancy Member Committee Interest Survey. There are materials online as well as in your binders. This is used by the next president to appoint members to the various standing committees, as well as to appoint the liaisons to the Qualifications Committee and the Enforcement Advisory Committee. So there is an attachment in here. I will point out, this is really for all of our board members. If you are willing to serve at the pleasure of the next president, please help that president out by turning in the form and at least indicating a preference of areas that interest you the most. So I would strongly encourage you to do that. You'll fill that out, which is attachment number 1, and if you can return it to Ms. Reed by Friday, December 2nd, your assistance would be provided. So for those newer board members, if you're on our board, please read this and take the time to think about how you can assist with leadership the next year. So with that, the next item is E, as National Association of State Boards of Accountancy Committee appointments. So I do just want to announce that I am very appreciative that our board members within this room took the time to consider how they could assist and help integrate with some of the national conversations happening at NASBA. And I would like to announce that we do have several board members that have been appointed to the National Association of State Boards of Accountancy Committees. And the first one is Mr. Lawrence Kaplan, who's been appointed to the Communications Committee. And that committee promotes the effective and efficient communication among boards of accountancy, NASBA, and stakeholders. I was appointed to the Enforcement Resources Committee, and that committee is to promote effective, efficient, and where appropriate, uniform enforcement of standards by boards of accountancy. Mark Silverman, Esquire, has been appointed to the CBT Administration Committee, and that committee promotes effective and efficient administration and operation of the uniform CPA exam. So you're getting the sense they're all very effective and focused on efficiency. The last appointment is Kathleen Wright, CPA. She's been appointed to the CPE committee, and that committee's job or role is to develop and promote uniform rules and requirements for continuing professional education among the various jurisdictions. So thank you very much for taking on those leadership roles and offering to step forward. So with that, we move on to item F, which is the announcement of the California Board of Accountancy Leadership Award of Excellence. And as part of the 2010-2012 strategic plan, this board developed an employee recognition program as a way to acknowledge our hardworking staff for their dedication and their efforts really in assisting this body with meeting its mission, which, as you all well know, is consumer protection. So as a result, the Leadership Award of Excellence was launched, and this is the 6th year that the award has been presented. So management evaluates all the staff working at the CBA and nominates those who best meet the criteria. And some of those criteria are providing consistently superior service through interactions with CBA staff, clients, and other external stakeholders. Another criteria is creating and implementing innovative practices, techniques, or systems resulting in significant improvements in service. And the last one, or one of the ones to highlight, is exhibiting a positive attitude regarding work and coworkers. And that consistent application, as you've seen with your own staff, is so important. So this year, the Board of Accountancy selected 2 staff members who have met and exceeded these criteria. And those staff members, I'm pleased to recognize, are Janet Zimmer and Allegra Keith. And so as not to embarrass them too much, I will take some time to just comment on both of them and thank them for all that they've done. But Janet started with the board in 2012, working as in the CBA's executive unit. And she was promoted to a staff services analyst and then to associate government programs analyst in the initial licensing and examination units. I think she got an award for just saying the title. But now she's serving as acting manager over those same units and taking that leadership role. Janet has exhibited the utmost professionalism as she performs her duties and is key in ensuring that the examination and initial licensing units meet established timeframes. She organizes and participates in board-wide activities and leads by example, reflecting a positive attitude in all that she does. And rather than asking the staff to come up, if I could ask Janet to stand to be recognized. And sorry for starting without you, but I'm glad you were here for that. Allegra, where are you?
Hiding in the back.
Hiding in the back. All right, so Allegra started with the board in 2013, working part-time in the reception unit, and she was promoted and hired on full-time in the executive office and was recently promoted to the position of executive secretary for Patty Bowers. She has an extremely strong work ethic and strives to provide superior customer service. Again, I saw her present that to me just today in our meeting where she was anticipating needs and handling them before I had time to even ask. She has a positive attitude and comes to work daily with a smile on her face. And for those of you who have had the opportunity to speak with Allegra, you know she goes above and beyond to assist with whatever you need. So I'd like to ask you to please stand so that we may thank you. So you're both assets to this board, and not only this board, really to the consumers within the state, because doing your job so well has really helped us do our job well, so thank you. Your understanding of the mission and your contributions really have gone a long way to help us and meet that. So we will have a certificate that we will present to each of you later, but I would like to at least let you know that the certificate reads, "This award is presented in recognition of demonstrated competence, dedication, and outstanding service in supporting the endeavors of the California Board of Accountancy in achieving its mission to protect consumers." So congratulations again, and thank you so much. It's nice to give awards. That's very exciting. So, well done. All right. So I would like to move on to item G, and that I'd like to invite Christy Shields, our Department of Consumer Affairs Senior Attorney, to talk about some of the developments in our North Carolina case.
So I don't have anything to report at this time. In light of the next agenda item, I think we'll cover any of the developments that have come up since our last discussions.
I thank you for your brief presentation. Okay, item H. The next item I'd like to invite Aaron Bone to the table to present will be the discussion on the California Little Hoover Commission's report, Jobs for California, Strategies to Ease Occupational Licensing Barriers. Aaron?
My presentation will not be as brief as the previous one. Good afternoon, Madam President and board members. The purpose of this presentation is to discuss the recently released Little Hoover Commission report, which reviewed California's occupational licensing laws and presented findings on how those laws affect California's workforce. No specific action, however, is required on this item. In particular, the Commission's report focused on how California's occupational licensing laws have impacted four groups: former criminal offenders, military spouses, veterans, and foreign-trained workers. The full report is attached to this item and includes the Commission's findings and their 8 recommendations. Now, most of the actions suggested by the Commission would require action by the legislature or the governor's administration to enact. However, I would like to spend a few moments discussing the Commission's recommendation number 5. It's on page 38 of the report, if members care to turn there. And just briefly discuss how CBA's current practices relate to that recommendation. So, recommendation 5A, it suggests that each licensing authority post on their website the criteria used to evaluate applicants with criminal convictions. Now, currently, CPA applicants are informed through the CPA Licensing Applicant Handbook that they may be denied licensure if they are convicted of a crime that is substantially related to any act involving dishonesty, fraud, or deceit with the intent to benefit themselves or injure others. In addition, applicants are informed through that handbook that they could be denied licensure if they committed any act that, if performed by a licensee, would be grounds for suspension or revocation. Secondly, the CBA's criteria used to evaluate criminal convictions, including mitigating and aggravating circumstances, along with any rehabilitation criteria, can be found in the CBA's disciplinary guidelines and model orders, which is also published on our website. Moving on to recommendation 5B. When criminal background checks are necessary, the Commission suggests requiring applicants to provide certified court documents rather than manually listing convictions. Our applicant handbook informs applicants that they must provide a complete and accurate criminal conviction disclosure form. Our handbook as well only requests certified court documents if it is related to a conviction that has been dismissed. Recommendation 5C, to create an informal appeals process between an initial license denial and an administrative law hearing. Now, currently, if the CBA denies an application for licensure, staff will send the applicant a letter indicating the reasons why they were denied and informing the applicant that they may request a hearing before an administrative law judge. Prior to such a hearing, CBA staff may engage in settlement discussions with an applicant and consider a probationary license with certain terms and conditions. Staff are happy to conduct any research related to the Commission's findings or recommendations and report back to the board. Madam President, that concludes my remarks, and I will turn it back over to you for discussion or comments.
Thank you very much. Questions from the board members? All right, hearing none.
Okay.
I think that's it.
All right.
That
Thank
was
you very much.
incredibly easy. All right, okay. All right, that concludes item H, and we move along to item I, which is discussion regarding the United States Department of Education's decision to withdraw and terminate its recognition of Accrediting Council for Independent Colleges and Schools. So I'd like to turn the microphone over to Christy Shield.
So, under Business and Professions Code, Section 5094, one of the qualifying criteria for a CPA license is that the education that the licensee, or the applicant, has to be from a degree-granting university, college, or institution of learning, higher learning, accredited by a regional or national accrediting agency included in a list of these agencies published by the United States Secretary of Education. So that's why this topic is relevant to this board. If you're not familiar with the accrediting agencies that accredit higher learning in the United States, there are regional accreditors such as the Western Association of Schools and Colleges. So if you're familiar with that entity, they're considered a regional accreditor. There's also a group of national accrediting agencies. And the agency that we're discussing this afternoon is the Accrediting Council for Independent Colleges and Schools. It's a national accrediting agency recognized right now, anyway, by the Secretary of Education, the U.S. Secretary of Education. They are the largest national accreditor of independent colleges in the United States. And since one of the criteria through which people are able to apply for licensure is if they have education from a nationally accredited agency such as this one, there could be an impact to applicants if the U.S. Department of Education follows through on their recommendation to withdraw the recognition and essentially remove them from the list of recognized accrediting agencies. So one of the staff had done the analysis regarding schools that they're aware of that accredited in California, but once again, it's a national accrediting agency, so there could be other colleges outside of California that could be impacted, that if someone graduated from one of those schools could have, or didn't graduate in time, could be affected. Currently, the way that this board has interpreted 5094 of the B&P code, the education would be examined at the time of licensure. If you graduated from an accredited school and they were accredited at the time you graduated, then this board would accept that as qualifying education. So the people that potentially could be at risk are those that don't complete their education and graduate before any loss of accreditation occurs. So in any event, we just wanted to bring this to your attention as a possible impact to the applicant pool for your license. Any questions?
So I actually do have one question. You mentioned students who didn't graduate.
Correct.
But what about students who had a degree from an accredited program, but then took additional courses to fulfill a requirement? Would it impact them also?
I think you would look at when they took the education, was the institution, the educational institution accredited.
Okay.
That would be the fairest way to interpret your statute, although your statute is not crystal clear on that point. I think that would be the most logical interpretation, that if they met the standards by the Department of Ed at that time, then you would accept their education and training.
Okay, thank you. Are there any additional questions for Christy? Okay. All right, well, thank you very much for discussing that change. The next item is the DCA Director's Report on Departmental Activities. So I'd like to welcome Shelley Jones, Board and Bureau Relations Managers, to present to our board. Welcome.
Welcome. Thank you. Good afternoon. So thank you for letting me update you on just some of the things going on at DCA. On September 7th of 2016, Director Kadani and the DCA executive team conducted a 2-hour directors meeting with executive officers and board presidents. The purpose of the directors meeting was to update the board leadership on the department's activities, share important information, and answer questions. Several items contained in my update below were shared at that recent meeting. Under the Governor's Regulatory Review Program, review and approval of a fiscal impact statement is required for all proposed regulations prior to submission of a notice of proposed action to the Office of Administrative Law. Since 2009, the Business Consumer Services and Housing Agency has waived this requirement for DCA boards. Given an increase in the number of rulemaking packages disapproved by OAL due to issues of clarity and necessity, the agency has rescinded this waiver effective September 7th. The department is working with agency to develop timely processes by which DCA boards will submit their proposed rulemaking files, which will include the economic and fiscal impact statements to agency for review and approval prior to filing with OAL for publication. And the goal in that is to make the process as seamless as possible and not create any delays. On October 27th, the department hosted its annual distributed costs review and open house for executive officers, bureau chiefs, and board presidents. This meeting covered the department's budgeting process and how its costs are distributed to all of the boards and bureaus. Following presentations, attendees were able to visit with staff from all of the department's individual units in order to learn more about the services provided by the department, as well as have access to the individuals running these units. The department will be emailing all board and bureau advisory committee members an updated version of its guide to distributed costs and services, which outlines the budget process, how costs are distributed, and the services provided by the department. Board members, as you know, are required to complete orientation training within 1 year of their appointment and reappointment to the board. We would like to thank Ms. Hines for joining us yesterday at the final board member orientation for this year. Training dates for 2017 will be decided and distributed in December. Board members are also reminded that they are required to complete ethics, sexual harassment prevention, and defensive driver training. A reminder regarding required trainings was emailed to all DCA board members in September, and this email included details on training frequency and registration. If you have any questions, you can contact our office. As you may know, the department's Solid Training and Planning Solutions Unit is dedicated to organizational development and offers a wide array of services to DCA's bureaus and boards. On Wednesday, September 28th, the third Solid-sponsored Brown Bag Gathering for executive officers and bureau chiefs was held. The agenda included psychological safe workplaces, building a work philosophy, a peer panel, and an update on the Future Leadership Development Program. The peer panel includes executive officers of the Medical Board and Board of Pharmacy, Registrar for Contractors State Licensing Board, and the Deputy Director of Board and Bureau Relations. One of the initiatives discussed at the Brown Bag Gatherings is the Future Leadership Development Program, which is designed to assist the department and its programs in growing the next generation of bureau chiefs and executive officers. The program has 3 parts to assist in the development of managers into executives, one of which is providing training available alongside executive officers and bureau chiefs. Secondly, mentorship opportunities from executives throughout the department and its boards and bureaus. And finally, completion of special projects designed to benefit the participants as well as the department and its boards and bureaus. The projects will be designed to address specific problems or issues facing the department and its boards and bureaus, which are expected to be collected during the EO Brown Bag Gatherings. Also, as part of DCA's strategic plan, Solid launched the Employee Career Empowerment and Mentorship Pilot Program back in July. The pilot affords line staff flexibility to learn from various participating managers, and several DCA units are participating, including boards and bureaus of Board of Optometry, the Board of Vocational Nursing and Psychiatric Technicians, Medical Board, the Professional Fiduciaries Bureau, Bureau of Automotive Repair, Acupuncture Board, and the Bureau of Electronic and Appliance Repair, Home Furnishings, and Thermal Insulation. 100% of the participants surveyed recommended the pilot to other DCA employees, as well as expanding the pilot to other boards and bureaus. The pilot is voluntary, but if the board does wish to participate, they can contact the Solid's manager, Damon Nelson. And finally, this year the department is developing a new strategic plan for years 2017 through 2019. One of the components of the strategic planning process is a survey of stakeholders. The survey was electronically distributed to board members this past Tuesday, and we just wanted to ask to let you know that your feedback is vital, and we respectfully ask for your participation to help us in improving the department's services. That concludes my update.
Great. Thank you very much.
Thank you.
Board members, any questions for Ms. Jones? All right, well, thank you for coming here and being with us today and
Thank you.
presenting. All right, with that, we move on to item 2, which is the report of the Vice President. I'd like to introduce Ms. Alicia Burhow, Vice President.
Thank you, Madam President. This is item 2A. This is regarding the appointments and reappointments to the Enforcement Advisory Committee. This item is to recommend the following: the reappointment of Catherine Allinson and Nancy Corrigan, the reappointment of Nancy Corrigan as Vice Chair, and the reappointment of Joseph Rosenbaum as Chair of the Enforcement Advisory Committee. The Enforcement Advisory Committee assists the CBA in an advisory capacity with enforcement activities. So this includes reviewing closed investigation files, providing technical guidance on open investigations, and participating in investigative hearings. I have conferred with the CBA Executive Officer to verify that the individuals have met the appropriate requirements for license renewal and have demonstrated the skills and knowledge to serve as a member or in leadership capacity on the Enforcement Advisory Committee. So I would recommend the following for the Enforcement Advisory Committee. I'm saying that way too many times. Joseph Rosenbaum to be reappointed as Chair effective January 1st, 2017 through December 31st, 2017. Nancy Corrigan to be reappointed as Vice Chair effective January 1st, 2017 through December 31st, 2017. And Nancy Corrigan and Catherine Allinson to be reappointed as members effective December 1st, 2016 through November 30th, 2018.
Second.
All right, so we have a first for Ms. Burhow and a second for Mr. Campos. With that, we have a fully formed motion. Any member comments on this? I would like just to say, again, that on behalf of the board, I appreciate all of the hard work and those willing to continue that hard work on these committees. Public comment? Hearing none. With that, I'd like to call for the vote.
Leslie Lamana?
Yes.
Saoirse Leon?
Yes.
Jen Oyang?
Yes.
Deirdre Robinson?
Yes.
Katrina Salazar?
Yes.
Mark Silverman?
Yes.
Kathleen Wright?
Yes.
Alicia Burhow?
Yes.
Jose Campos?
Yes.
George Familet?
Yes.
Carrie Ann Farrell Hines?
Yes.
And Larry Kaplan?
Okay, with that, the motion passes.
All right, item 2B, this is for the appointments and reappointments to the Qualifications Committee. This item is to recommend the appointment of David Evans as Chair and the appointment of Kimberly Sugiyama as Vice Chair of the Qualifications Committee. The Qualifications Committee assists the CBA in its licensure activities by reviewing the experience of applicants for licensure and making recommendations to the CBA. This includes conducting work paper reviews with the applicant or employer present to verify that the responses provided are reflective of the requisite experience for licensure. So I conferred with the CBA Executive Officer to verify that each individual has met the appropriate requirements for licensure or license renewal and have demonstrated the skills and knowledge to serve in a leadership capacity on the Qualifications Committee. I recommend that David Evans be appointed as Chair and Kimberly Sugiyama be appointed as Vice Chair of the Qualifications Committee effective January 1st, 2017 through December 31st, 2017.
So we have a first. Do I have a second?
Second.
All right, the second goes to Ms. Lamana. Member comments? Public comments? Okay, hearing none, I'd like to please call for the vote.
Kathleen Wright?
Yes.
Mark Silverman?
Yes.
Katrina Salazar?
Yes.
Deirdre Robinson?
Yes.
Jen Oyang?
Yes.
Saoirse Leon?
Yes.
Leslie Lamana?
Yes.
Larry Kaplan?
Yes.
Carrie Ann Farrell Hines?
Yes.
George Familet?
Yes.
Jose Campos?
Yes.
And Alicia Burhow?
Yes.
With that, the motion carries.
Okay, finally, item 2C. This is for the appointment or reappointment to the Peer Oversight Committee. This item is to recommend the appointment of Jeffrey DeLizer as Chair and the appointment of Kevin Harper as Vice Chair of the Peer Review Oversight Committee. The Peer Review Oversight Committee assists the CBA in an advisory capacity in its oversight of the peer review program. As with all appointments, I have verified that the individuals have met the requirements for license renewal and have demonstrated the skills and knowledge to serve in a leadership capacity on the Peer Review Oversight Committee. So I would like to recommend that Jeffrey DeLizer be appointed as chair and Kevin Harper be appointed as vice chair of the Peer Review Oversight Committee effective January 1st, 2017 through December 31st, 2017.
All right, so we have a first. Do I have a second? All right, thank you. Ms. Robinson has given a second. Member comments? Public comment? Okay, hearing none, I'd like to please call for the vote.
Larry Kaplan,
Yes.
Carrie Ann Farrell Hines. Yes. George Familet,
Yes.
Leslie Lamana,
Yes.
Soshi Leon,
Yes.
Jen Oyang,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar.
Yes.
Alicia Burhow,
Yes.
Mark Silverman,
Yes.
Jose Campos,
Yes.
and Kathleen Wright.
Yes. All right, thank you. With that, the motion carries. And before we move on, I would just like to congratulate all of our folks that have just been reappointed and thank them. Item 3 is a report of the Secretary Treasurer, and that is being handled today by Ms. Burhow as well.
Thank you very much. This is regarding the first quarter financial report. Regarding our budget, the California Board of Accountancy's fiscal year 2016-2017 budget is all set at $14,762,000. Regarding our revenues and total receipts, on attachment 1, as shown in the attachment, the CBA collected approximately $2.2 million in total revenue for the first quarter, and this represented an increase of 41% from the same period in the previous fiscal year. Revenues are expected to increase throughout fiscal year 2016-2017 due to the end of the 2-year fee reduction and are projected to be about $13 million. Moving on to expenditures on attachments 2, 3, and 4. Total expenditures for the first quarter shown in attachments 2 and 3 were $3.98 million and reflect a 5% decrease from the same period in the previous fiscal year. This is primarily related to a decrease in the facilities costs resulting from the location to the new building. Printing costs are also elevated, but remain consistent with the same period in the previous fiscal year. The enforcement-related expenditures, as shown in attachment 4, increased 22% over the same period for the previous fiscal year, primarily due to a restructuring of resources and streamlining of procedures, which have allowed for increased complaint processing. General fund loans and reserves on attachment 5. The CBA began fiscal year 2016-2017 with 10.4 months in the accountancy fund reserve, as shown in the attachment. In July of 2016, the Department of Finance issued its current loan obligation report, identifying target dates for repayment of the CBA loans made to the state's general fund. So the remaining 3 loans totaling $21 million plus interest are scheduled to be repaid in June of 2017. So this will bring the general fund loans balance to 0, and the next loan obligation report is due to be issued in January of 2017, and we'll provide an update on the planned loan repayment schedule. So should the loans continue to be scheduled for repayment in June 2017, then the CBA's reserve fund will increase to approximately 26 months. Authorized positions and position allocation, this is in attachment 6. The CBA presently has 90.9 positions, and this reflects the expiration of 5 limited term positions in the enforcement unit and the addition to 2 clerical positions in the administration unit that were added via a budget change proposal for fiscal year 2016-2017. At this point, that is the report, but if there's any questions, I'm happy to answer.
Questions from the members? All right, hearing none. All right, so with that, that I believe concludes
It
item
does.
number 3. Thank you very much for stepping forward and handling that. The next item, number 4, is actually a closed session. So what we will do is the board will meet in a closed session pursuant to Government Code Section 11126A1 to conduct its annual evaluation of its executive officer. We will take a 5-minute break to, yes, sir, Jose has a suggestion.
Should we not just move all of the closed session stuff to the end of the day instead of breaking for closed session now?
How long will it take to break for closed? About 5 minutes? To set the setup to go dark and then come back.
I'm just
It
suggesting
takes
to
5 minutes to
combine
break.
all the closed sessions toward the end and
I
continue working our way
will
through the
agree with the will of the board as a whole. By show of hands, since we don't need a vote, could we show who wishes to defer this to the end of the day? Okay, so we have a majority that wishes to. So with that, we will table item number 4, and we will come back to it. We've already handled lunch. Jose, we're good there. I won't break again.
That's why I'm not as grumpy as you.
Oh, you're always delightful, Mr. Campos. Item 5, we move along then to the report of the executive officer. Patty, are you prepared for
I am,
that?
absolutely.
Great, thank you.
So with the permission of Madam President, I would like to ask a couple of the staff members to go ahead and come forward who will be assisting in the executive officer's report. I'll cover the first 2 items before turning it over. So the first item, the update on the relocation of the board office, that is going very well. Everything is in place, and we have what appears to be a pretty firm move-in date, and that will be the second weekend of February. So we're very excited. We have
Firm.
fairly firm. I qualified it. Fairly firm. We have a team of staff. We're now meeting with the engineers, contractors, and new building owners on a weekly basis. It's a beautiful building, and things are going very well, and so we're getting very excited. The next item under my report is a quick update on staffing. I'm just going to highlight a couple of the staffing updates, and then I'll leave it to our division chiefs to add any additional staffing updates under their division reports. We've had 3 recent internal staff promotions that I wanted to highlight. The first one, Veronica Daniel, who, as you all know, has served in many capacities in the board office, most recently as our licensing manager. She was recently appointed as acting licensing chief, filling the position behind Gina Sanchez while she's out on maternity leave. So congratulations to Veronica. And then the 2 additional internal promotions, which were mentioned, both of the staff members in the Employee Award of Excellence earlier today. Janet Zimmer in our licensing division has recently been promoted into an acting capacity, serving behind Veronica. And then Allegra Keith, who previously served as Deanne's assistant, thank you very much, Deanne, has recently been promoted, serving as my secretary now. And so I appreciate Deanne's flexibility, and we are quickly recruiting to find Deanne a new assistant. So with that, I will be happy to answer any questions and then turn it over to Mr. Bone.
Okay, all right. Nice to be before you again this afternoon. This is the outreach report, item VC. The fall's been a very busy time for us for CBA outreach activities. On September 27th, staff participated in Cal CPA's So You Want to Be a CPA webcast. That event was estimated to have reached more than 100 individuals enrolled at California community colleges and employed at CPA firms throughout the state. On October 11th, Board President Salazar addressed accounting and taxation students at Golden Gate University on the topic of leadership and the accounting profession. In addition, staff joined a career fair held on October 24th at a local high school here in the Sacramento area, where we discussed the educational requirements for licensure and potential career paths to become a CPA. On November 10th, President Salazar and CBA staff attended another Cal CPA event that they sponsored. This was held at CSU Sacramento here in town. More than 100 students majoring in accounting attended and listened to a panel of CBA presenters discussing their career and personal experiences as a CPA. Board staff spoke with many of the students in attendance and discussed licensure requirements. Finally, on November 30th, President Salazar will be speaking at Cal CPA's new licensee welcome event being held in San Francisco. We're very pleased to partner as well as we are able to with Cal CPA. They're a great group to be able to work with and on outreach events, and I look forward to continuing to do so in the future. That concludes my remarks, Madam President.
Thank you.
The next item up is to provide the CBA with an opportunity to discuss whether a change to its current 16-member qualifications committee is necessary and appropriate to support establishment of meeting quorums. As identified in the item, over the past few years, the QC has experienced a number of challenges, including consistent vacancies and a decrease in interest to serve on the QC. Despite increased outreach efforts in the area of recruitment, these situations have resulted in issues with establishing meeting quorums. To effectively facilitate future meetings, the CBA may wish to consider a reduction in its current QC membership at this time. Staff's recommendation for this item is to essentially remove the 3 standing vacant positions, which would lower the QC membership to 13. The new quorum requirement would become 7 members. This change would make it easier for the QC to establish and maintain a quorum. It would also alleviate the immediate need to recruit for the 3 vacant positions where no pending applicant pool exists. There would be no significant impact to the operations of the QC. The change would also make the QC membership consistent with that of the Enforcement Advisory Committee, which also operates with a membership of 13. With the concurrence of the QC chair, staff recommends the CBA consider adopting a motion to reduce the number of QC membership to 13 members and direct staff to make necessary revisions to the CBA member guidelines and procedures manual, which is provided in the attachment, as well as any committee-specific resource guides or manuals. At this time, I'll turn it back over to President Salazar.
Okay, before we entertain a motion, were there any clarifying questions for Ms. Daniels from the
Yeah,
members?
two questions. You said with the concurrence of the QC chair, is there general agreement among the overall QC that this is an appropriate move?
The QC has, considering that it has had to cancel a meeting earlier this year, the QC does stand, my understanding is in concurrence with this recommendation today.
Okay. And you mentioned there wouldn't be any significant impact on operations, and so they review experience type of items. What kind of backlog do we have right now on things that we would like the QC to review for staff?
The QC is current in its activities. From meeting to meeting, the candidate pool gets addressed at each follow-up meeting depending on the Northern or Southern California location. So we will hold any Northern California applicants until we have a meeting in Northern, and then vice versa for Southern. We also hold off-cycle meetings to catch any interviews in between from meeting to meeting. But in terms of the other work, it does perform an annual file review, which it is current on as well. So to answer your question, there is no backlog in the work for the committee.
Okay, and last question is, what happens with matters that maybe you would like to send to the QC, but maybe there's not a meeting happening? I assume you have an alternative or an internal path towards reviewing that information that you would undergo. Is that kind of the business decision that we have to make here, that some things maybe just end up being dealt with internally?
Right, so the QC is only works on items that it is authorized to work on. So outside of any items that are within its current authorization, it would need to be directed to do any additional work by the board. So right now, there isn't anything pending outside of that.
Okay, Ms. Wright, do you have a question?
Thank you. In light of the change in the continuing education, not continuing education, I'm sorry, the qualification educational requirements that come into effect January 1, 2017, has that been considered with respect to the impact that that would have on the qualifications committee? Will there be, and translated, will there be more work as a result of the new requirements for this committee?
We don't anticipate that causing an increase for the QC. Its primary authority is to review candidates' experience. So in terms of education, that is still reviewed internally at the staff level.
Okay, so they don't get involved in the evaluation of qualification of courses to meet the new requirements?
Correct.
Okay.
I move to approve the reduction of the QC membership from 16 to 13.
Okay, we have a first from Mr. Campos. I'm not sure if that was Mr. Silverman. Mr. Kaplan wins out. We'll take a second from Mr. Kaplan. Thank you. Additional member comments regarding the motion on the table? Public comment? Okay, hearing none, I'd like to call for the vote.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Jin Oyang. Yes. Soshi Leon,
Yes.
Leslie Lamana.
Yes.
Kathleen Wright,
Yes.
Mark Silverman,
Yes.
Alicia Burhouse. Abstain. Jose Campos,
Yes.
George Family,
Yes.
Carrie Ann Farrell Hines. Yes. And Larry Kaplan.
Okay, thank you. With that, the motion carries. And that concludes the reports. Thank you both for those presentations. And that concludes item 5. We move along to item 6, which is the report of our committees. So my understanding is that the Enforcement Advisory Committee does not have a report today. The next is the Qualifications Committee, and so I'd like to invite Ms. Jenny Bolsky to the table to present on the report of the October 19th, 2016 QC meeting activities. Thank you for joining us today.
Madam President and members of the board. First, I would like to thank you for approving the reduction in the QC. We believe that will facilitate our establishment of quorums at business meetings.
Could you move the microphone a little closer so that we can...
How's that?
And yell.
Closer? Even closer.
Just yell.
How is that?
Much better.
I was thanking you all for approving the reduction in the QC membership, which we believe will facilitate the establishment of quorums at our business meetings. I'd like to report on our most recent meetings. Since I saw you last, the QC met on October 19th at the CBA in Sacramento. And at that meeting, we performed our annual audit of files that represent candidates who were approved for licensure. We reviewed a sample of 100 files, and the members of the committee concurred with staff assessments on all 100 files. Secondarily, we had a subcommittee meeting, or I shouldn't say we, there was a subcommittee meeting in Southern California on October 26th. At those two meetings, the Qualifications Committee and Subcommittee meetings combined, we considered 6 Section 69 cases. Of those, 5 candidates were recommended for approval of licensure. 1 candidate was deferred, and that was it. On July 27th, the QC identified the possible need to revise the certificate of a test experience that's currently in place due to some changes in our professional standards. This is something that I will work with the staff.
Can you repeat that one? That one's, I didn't quite get
That one caught you by surprise. At our July 27th meeting, the members of the QC identified the potential need to revise the certificate of a test experience. That's the certificate that candidates must submit as part of their licensure application process. And because of some changes in our professional standards, there is potentially the need to update that certificate or the form that the candidates must submit. So I would like to work with the staff going forward to obtain authorization for improving or making recommendations to this form if necessary, basically evaluating the form as it is now and recommending changes if any appear to be warranted. Any questions on that? Does that make sense?
Got it.
Finally, the next QC meeting will take place on January 25th at the Wyndham Irvine Orange County Airport in Irvine, California. And that is the day before the next CBA meeting. So we would be delighted to welcome any of the members of the board if they wish to attend the QC business meeting. And that concludes my report. Are there any questions?
Thank you for that invitation, and we do have a liaison, but for those members who haven't had the opportunity, it is really quite an interesting opportunity to get to talk with those that are participating and also just observe the work that goes on. It is significant, and it is, I don't want to say there's a lot of it, but I do appreciate the hard work with those committee meetings. So, and also your minutes, which did address some of that. The comments you made regarding the certificate of attest experience. I do have a question for Patty. Do we need to, as a board, make any direction to staff to continue that conversation with the committee?
I think it would be helpful. We've really worked over the past couple of years to narrow the activities of our committees to items only authorized by the board, and so I think it would be helpful if we could have a formal assignment to them.
I do understand that since it isn't agendized, must that request be formally in the form of a motion? Okay, so we're fine then.
Well, I think just to be clear, obviously it's this board's responsibility with respect to that attest experience form, but given the vast amount of assistance that the QC performs on behalf of this board and staff, I think it would be helpful to understand and hear the recommendations that the QC would have with respect to that form that could inform a future agenda topic on that topic.
And may I ask a clarifying question? My understanding was this had to do with the reflection of the new preparation engagements as including those, or incorporating those references into the form in some
You're
fashion.
veering off the agenda, Ms.
No, I asked a clarifying question about
Yes,
what she mentioned.
yes, that
That was
is
my clarifying
correct.
question.
Changes regarding preparation engagements, yes.
Okay, thank you. All right, so with that, we will cease veering from our agenda in any way, shape, or form, and thank you for that presentation.
Thank you.
And then the next items are peer review oversight committee, and as my understanding that we do not have a report. However, I do want to thank Bob Lee, who is our PROC chair, and Jeff DeLizer, who is the vice chair, for joining us today and for continuing to participate and attend, even though they do not have any reports. So again, thank you very much for that. And we look forward to the next reports from your committees.
And frankly, for his service as chair for a long period of time and good work on the PROC.
Concur. All right, the next item moving along is item number 7. So I'd like to invite Mr. Dominic Franzella to the table to give the report of the enforcement chief. Thank you.
So thank you. Item 7 is the enforcement activity report, and it is highlighting information over the first 3 months of this fiscal year, so as of September 30th, 2016. I'm just going to highlight a couple of items in the interest of time. And so I'll start on page 2 of the report, and specifically so far this year, we've been successful in closing more matters than have been assigned, and this has had a positive effect in that we've been successful in lowering our average day to close from 189 days down to 157 days, and so a lot of that stems from staff's increased efforts, as well as a lot of processes that we've improved upon and work to kind of streamline and all the efficiencies that we're working to implement in the enforcement division. Moving on to page 3 in discipline. So far this year, we've referred 27 matters to the AG's office, which is a similar pace for the last 2 fiscal years. We've also filed 28 accusations during the same period, and it is consistent with last year's totals. The disciplinary actions the board has taken shows 17 so far, but another 17 took effect just after this report was run in October. So the number is higher at this particular point. Moving on to citations on page 4. Over the first 3 months, we've issued 32 citations. I do anticipate this number to increase over the course of the year. However, I do believe the CBA will be issuing fewer citations in total. Over the past year, we've worked really hard to improve our letters and methods of communication for more of the administrative type violations in an effort to emphasize and obtain compliance with this, which is consistent with what the board's message has been over the last 2 years that I've been in this position. So we're really working to obtain that. And also that's helping, it corresponds back to how we're being able to close cases faster because our communications are more effective and efficient than they historically were. Moving on to probation monitoring, we have 108 probationers. We've made a significant push to schedule orientations early on so as to meet with probationers at an early stage during the probation to ensure they clearly understand the terms and conditions and that the probation period can be as successful as possible. In August and September, we held 10 orientations. We conducted another 3 this week, and another 8 are already scheduled for December 1st in Irvine. And we're handling these off cycle. Normally they used to be handled with the EAC. If that works out, we do. Otherwise, we make arrangements to meet at state buildings or make telephone calls or have them come to our office in an effort to be as flexible as possible and get to the probationers as early as possible. Moving on to the last couple of pages, pages 6 and 7, I really want to just focus on the division highlights. In the division highlights, you'll see a table on disciplinary action taken by the CBA regarding tax-related issues. This is being provided in response to an inquiry at the last meeting on this particular topic. Staff looked back between July 1, 2014 and August 31st, 2016 and identified 163 matters on which the CBA took action. 18 of those related to tax issues. We provided a breakdown of the type of decision, whether or not it was a default, stipulated, or proposed, and the order that resulted, whether or not it was a revocation or denial, surrender, or probation. So that's informational statistics based on a request from this body. We continue to recruit for a handful of positions in the division, but we have been successful in filling 3 important positions with internal promotions. First, Ben Simcox has recently been appointed to the Staff Services Manager 2 position within the Enforcement Division. Ben is here today. And this is a newly created position that I'm really excited about because it's a position right below me that I can use effectively.
Did you say abuse effectively?
Abuse effectively.
I heard that too.
Corey Reardon has been selected to serve as the Staff Services Manager 1, overseeing the board's non-technical investigations unit. Corey is also here today, and many of you knew Corey from her time as the Board Relations Analyst. And Allison O'Connor has been promoted to the Staff Services Analyst in the Citation Unit. Allison's been with our board for many years, and we're happy to have her take on this new role. On 2 final notes, one of the strategic plan objectives in the board's enforcement, or in the board's strategic plan is an objective for enforcement to increase collaboration with other regulatory agencies. And so staff recently working with the DCA's Division of Investigations on a matter, worked with them on a matter that led to charges being filed by the Los Angeles County District Attorney's Office related to unlicensed practice. The CBA received a complaint regarding unlicensed practice and the individual accepting $15,000 in audit fees to perform services. She signed the audit reports as a CPA, and she was not any longer a CPA, and the reports could no longer be used or relied upon. Eventually, the individual pled to an agreement that ordered her to pay restitution to the victim, and she was sentenced to 5 years probation. The individual was a prior licensee of this board, but in 2010 had their license revoked. So we are working as best we can with other agencies to ensure the safeguards of consumers. Lastly, we are making an increased effort on enforcement training. We have a number, I want to say close to 17 or more staff today at the Enforcement Academy that's put on by DCA. It is a recently restructured academy. I had an opportunity to sit on and work through the curriculum and the divisions of the classes and how it'll be put together. And now they're offering this particular, I believe it's 13 classes, and staff need to take 6 or 7 core classes and 2 electives. So we've created a chart and worked through what staff need to be taking which courses and working to ensure staff have the opportunity to earn the Enforcement Academy certificate, both for our benefit as increasing their education and training, but also for their own benefit for upward mobility. So with that, I'm happy to turn it back over to members and answer any questions you may have.
Great, Ms. Wright, question?
Thank you. Dominic, on the tax-related issues, new section, thank you for including that information. One quick question. Were those items primarily taxpayer complaints as opposed to agency referrals?
I don't really have an exact answer for that. I presume it's a combination of both. Many of our tax-related issues come from external complaints, not necessarily referrals from the IRS or FTB.
Thank you.
Additional questions?
Yeah, 2 questions. The great work on closing cases and reducing the number of days, and I think I heard in your comments, your process, the vetting diligence, all of that remains the same, if you will, in terms of what's required and what we need to do. And I take it that it's the streamlining of certain processes and the focus and what have you that's really driving the closure of these items, as opposed to anything we've eliminated in the vetting process or what we think appropriate to close matters out with.
Yeah, one of the steps we really took was a lot of our inventory is self-generated in terms of internal complaints, things that come from renewals, and on a lot of the administrative violations, one of the steps we've taken was sending out email communications at the onset, waiting a day or 2, and then sending out letters and then doing additional follow-ups. And so that's really helped us at an early stage try to get compliance within the first 30 days or so. And that really helps with the inventory control and also helping to drive down the numbers. We're not eliminating any steps. We're not, if anything, we actually added a step, but it's a step that's to the benefit of the board and to the licensees.
So that's good to hear. And then the more of a numbers question here. So if there's an item in the investigations table and you refer it to the AG, I'm assuming it comes off the investigations item as either closed or something, and then it moves into the AG referral area. And then if you take discipline and we close that out, and they happen to be on probation, it comes off the AG table, and then it goes over into the probations monitoring side?
Yeah, it'll either go from investigations to discipline or stay in the investigation table as a close, like you'd mentioned, or it could move to the citations table as well, and then to the probation monitoring. But the majority of the ones that are the aged ones tend to go to the AG table and into the probation monitoring.
Okay, thank you.
Any additional questions, comments? All right.
Thank you.
Well, thank you very much for that report. The next item is item number 8, so I'd like to welcome Ms. Veronica Daniel, Acting License Chief, to the table to present with a report of the licensing chief. Welcome back.
Thank you. I would first like to acknowledge our newly appointed interim licensing manager, Janet Zimmer, on her well-deserved achievement of both the promotion as well as Leadership's Award of Excellence. Congratulations to Allegra as well, as she does provide a lot of support to our division. The licensing activity report reflects licensing division statistics for fiscal year 16-17 as of September 30th, 2016. Page 1 identifies the volume of contact each unit has, or each unit within the division has, with our applicants and licensees. As you can see, stakeholder contact has continued to increase in most areas of our division. Pages 2 through 5 cover the highlights and statistics for the examination and initial licensing unit. The unit is currently processing first-time applications for the uniform CPA examination within 39 days and repeat applications within 8 days. Applications for initial CPA licensure are currently being processed within 28 days. We are currently recruiting to fill 4 vacant positions in the unit. As part of our oversight of the administration of the uniform CPA exam, at the conclusion of this week, the CBA will have visited all 20 Prometric Testing Center locations, including the new location in Stockton. In the next few weeks, we will be sending letters to seek individuals to participate in site visits and as secret shoppers for Prometric Testing Centers in 2017. The unit has started seeing an increase in applications from individuals who wish to become licensed in advance of the changes to the Ethics Study educational requirement, which is set to take effect January 1st, 2017. We will be keeping a close eye on this area and ways to mitigate any impact to our current processing timeframes. Page 7 begins with the statistics for the License Renewal and Continuing Competency Unit and provides our total licensee population, which is reflected on the graph for the prior 3 fiscal years. That concludes my report for the licensing division. I'll turn it back over to President Salazar.
Okay, thank you for the presentation. Board member comments or questions?
Yeah, I got a couple questions. I saw the average days to close on the, what was this, on applications? And my question was really, individual licensee applications, average days to close of 26, so I assume some go real fast and some take longer. And my question is more, do we have any qualitative sense on any backlog there? And what I'm talking about is maybe things that have been sitting for 90 days or more, things like that. And to the extent you have any qualitative comments on the extent of that, be great, or if not, maybe it'd be something to include in the narrative going forward to start getting a sense of what are the more troublesome areas and what kinds of things kind of drive that.
Right, so I know the board has been informed of the licensing performance measures that were submitted to the legislature earlier this year, and I believe for complete applications, and that means an application that we receive, that once we receive it is complete, the average processing time frame for those was 31 days. Our board stats reference from the date, it references approved or complete applications and incomplete applications in composite. So once we have the final document to complete an applicant's file, that's when that date starts for that 30 days. So if somebody submits an application and it's incomplete, we notify them of a deficiency. And our typical notification of a deficiency is within our target 30 days. Once we receive that pending item, then we would consider the time from when we process that pending item to when we pre-approve them. So that time frame is within 30 days as well. So to best answer your question, there are different ways that we calculate for board stats versus the licensing performance measures, and there may be some review time which is outside of the 30 days, but that average does bring us, down to it. I would say generally if it's going beyond the 30, it's really, we're really not going too far beyond that. When we do receive an influx in applications, it really may be a week or so beyond that, but for the most part, right now, we are currently processing within that time frame.
So to make sure I understood, the average days to close statistic, is that just for complete applications, or does that include the composite aspect of incomplete applications that are sitting there?
The board stats before you today include the composite of the complete and incomplete.
Okay, that's helpful. So it'd be driven by incomplete apps that would drive that. The other question is with the general versus the attest licensing option. Are you seeing a large number of folks reapplying later? How does it appear in the stats when somebody then applies at some future date, once they're general licensed, to move to an attest license?
So we call those conversions, when somebody converts from a general license to an attest license, or with the authority from general to attest. And that information isn't necessarily captured in our stats and composite with the approved applications here. If it is of the board's interest to hear of that information, we can.
Is that a large scope of work for you all right now, or is that just kind of normal trickling in type of stuff?
For conversions, I would say we're probably looking at maybe under 20 a month, and please don't, take my word for that, but I would say approximately 20 per month.
So small portion.
Small portion, and we've already reviewed the file from front to back in detail, so it really is us, looking at just those 500 hours or the requirement for the attest.
Okay, thank you.
Okay, Mr. Famlott?
Delinquent CPA licensing, you have a footnote there, but it makes it look like almost 10% of licensees, or 9,000, are delinquent. Is that mostly just people that have been sent a renewal form but haven't gotten it back to you?
Right, so.
I'm sorry, could you restate the question? It was a little hard to hear.
Oh, sorry. In terms of, on page 6, I was asking about the delinquent description, where we have about 9,000 applications that are showing as delinquent, and I just wanted to get a sense, is the majority of those the applications which have been sent but not completed and renewed? That kind of surprised me that number was so large.
Mm-hmm. So my understanding is that it's in composite of licensees who have not submitted their renewal form yet, so they've gone into a delinquent status, and those who have a renewal in process pending review of staff. So it would be those that we do not have an application for, and those that we do, but it's pending the review.
Okay.
And we do have, if I could call Cindy up, we do have her as the subject matter expert on the topic.
The delinquent people can include a population of those CPAs who have elected not to renew. So they have 5 years from their license expiration date to decide if they would like to renew. So that's a great portion of that population are licensees that have just elected not to continue on in the profession.
Okay, fair. Thank you.
You do on page 7 list, I'm sorry, did I interrupt?
No, please, proceed.
On page 7, you have a table that further breaks down these renewal deficiencies, if you will. The 1,270 that have their outstanding deficiencies, and then you list what the top 3 kind of are, right? Peer review and application ethics. Do those tend to stay out there a long time? Do these folks just leave them unattended, or do you see quick responses once these deficiency notices go out?
It varies. As you can see, we issue over 700 deficiencies on an average in a month. And so it just depends on how quickly the licensees respond. We do follow up with a second notice to inform them that they have not yet responded.
Yeah.
So these can be vary over a period of time, but once if they have not responded, then we take action.
You list the top 3 reasons there. What are the, I guess anecdotally, what are the things that right behind it? Like what other kinds of major reasons are there for people having these outstanding deficiencies?
So we have the peer review, the renewal application, and the ethics education. And I believe the next one down would be more continuing education, like failure to submit your continuing education, then into accounting and auditing and fraud and those type of issues.
Yeah, 2020 or things like that.
Correct.
Okay.
Ms. Bowers?
And then just for clarity on as far as the next step. So once someone submits a renewal application to us, giving us notification that they are intending to renew, which then would suggest that they are also practicing, and we find the deficiencies, if there's not success through the renewal unit in bringing them into compliance, that's when that matter then goes over to our enforcement program. There's an additional, more recently, we've increased our additional assistance from the enforcement division in gaining that compliance. But if after those efforts are exhausted, there's not remedy of the deficiency, then most of those would end up in the citation.
All right, any final questions? All right, thank you for both the presentations as well as the questions that our members have asked. Thank you very much. All right, so that concludes item number 8, and the next item is 9, which are our committee reports. So the first committee to report is the Committee on Professional Conduct. So I'd like to welcome Ms. Leslie Lamanna to
Thank you.
proceed.
The committee met this morning, and we had 2 main topics of discussion. The first being item number 9A2.
Actually, you know, my apologies. We are moving along to the committee reports, and Ms. Wright, did you wish to make a
Okay.
statement on
I don't know what the result was because that's fine, I will. Yes, I should recuse myself on the advice of DCA counsel. I do not agree, but I am going to recuse myself nonetheless because of their recommendation and letter to me.
Okay. And then we will make sure that you are notified when we've moved past the CPC report.
Okay.
So if you could just wait.
Go ahead. In May 2015, NASBA, jointly with the AICPA, proposed changes to the standards of continuing professional education programs, which is in your binder. These became effective September 1st, 2016. Among the most significant of the proposed changes was the addition of nano-learning and blended learning, 2 new delivery methods for CE programs. California is one of the few states that, rather than pre-approved CE providers or programs, requires licensees to select appropriate programs from CE providers that conform to the minimum program requirements outlined in Article 12 of the CBA regulations. I will give an overview of the various standards and then have a final motion at the end. First is on nano-learning, as defined in the standards, a 10-minute interval course through the use of electronic media and without interaction of a real-time instructor. A nano-learning course is awarded 1/5 of CE credits and is not a substitute for comprehensive programs addressing complex issues. The standards require a qualified assessment of 2 questions with a passing score of 100% and issuance of a certificate of completion. The CPC believes that nano-learning should be implemented as a method of learning and decided that no limit was necessary for the number of hours. Blended learning is a program incorporating multiple learning formats. The standards require a blended learning program include learning objectives and instructional methods needed to guide the participant through the program. The CPC believes blended learning should be implemented as a method of learning due to the flexibility it provides licensees. Program measurements, as stated in the standards, allow CE credit to be earned in 1/5 and 1/2 increments after the initial first full credit is earned, with the exception of nano-learning. Currently, CBA regulations only allow CE credits to be earned in half-hour increments once the first full credit is earned. The CPC believes the increased flexibility should be provided to allow CE credit to be earned in 1/5 increments. Live programs are determined based on how the participant consumes the learning and not by the technology used in delivery. They require at least 1 element of engagement during each CE credit and identify that a real-time instructor is required. Self-study requires additional review and assessment questions for credit earned after the first full credit, and use of simulations and other innovative tools in lieu of review questions. Additionally, the standards allow the final assessment to be completed during the program with a passing score of 70. Program reporting requirements, as stated in the standards, require documentation is maintained evidencing elements of engagement, meaning tests, or of group live programs, as well as document retention of instructions and information to participants regarding components comprising a blended learning program. Group internet-based programs are determined based on how the participant consumes the learning and not by the technology used in delivery. The standards provide setting examples, but stipulate the settings are not limited to these specific examples. So the CPC recommends that the CBA implement changes to the continuing education requirements as follows. 1, allow for nano-learning that excludes ethics, fraud, and regulatory review, and direct staff to develop draft language for a future meeting at which time the CBA may direct staff to initiate the rulemaking process. 2, allow for blended learning and direct staff to develop draft language for a future meeting at which time the CBA may direct staff to initiate the rulemaking process. And 3, and for program measurements to allow for 1/5 increments as identified in the standards for all delivery methods, and develop draft language for a future meeting at which time the CBA may direct staff to initiate the rulemaking process.
Okay, so, did you have a comment?
Well, I just want to make sure that you take each of those separately, just because they were all separate motions.
Okay.
Okay, so we're going to take them separate. Okay, item 1 was on the nano learning.
Okay, so if I may rephrase for clarity, would that be helpful? Do we need a?
Why do they need to be separate? I don't understand. I mean, we went through them separately as a CPC just from a deliberation standpoint, but at the end of the day, we have an approval of 2 things.
I think it was
Don't
just
get it.
because each one of them was handled as a separate motion and voted on separately, so to allow discussion on each separate item and public comment on each item.
Okay, so we have the first one, which is a motion to implement. Could you repeat that with the microphone a little bit closer, that comment?
So the recommendation was that since the committee voted on each topic separately and to allow for public comment and discussion on each item separately, I recommended that you handle the motions as presented from the committee.
So we have a motion put forward, fully formed by the committee, that I will paraphrase for just clarity. I'm not changing it, but the motion is to implement nano learning option within the regulations, but not modify ethics, fraud, or the regulatory review requirements. So we have a fully formed motion from the committee. Member comments? Mr. Silverman? Pardon me? Well, we actually came fully formed, so we don't need a first or a second, and we're now just at the board discussion on nano learning. Okay. I'm sorry, yeah, okay. I'm giving everybody time to let this sink in and make sure, okay. Is there any public comment from audience participants on nano learning? Okay. Hearing and seeing none, unless the committee members have any additional comments that they just forgot, we will go ahead and call for a vote.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familet,
Yes.
Carrie Ann Farrell Hines,
Yes.
Larry Kaplan,
Yes.
Mark Silverman,
Yes.
Katrina Salazar,
Yes.
Deidre Robinson,
Yes.
Jin Oyang,
Yes.
Soshi Leon,
Yes.
and Leslie Lamona.
Yes.
Okay. So thank you. With that, the motion carries, and we move along to the second fully formed motion that I will rephrase just for clarity. That's the motion to implement blended learning as an acceptable type of CE learning. So that comes fully formed. We do not need a first and a second, but we now open to member comments regarding blended learning. Okay. Hearing none, how about public comment? Do we have any audience participants that wish to comment? Okay. Seeing none, then I would like to please call for the vote.
Mark Silverman,
Yes.
Katrina Salazar,
Yes.
Leslie Lamona,
Yes.
Soshi Leon,
Yes.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familet,
Yes.
Carrie Ann Farrell Hines.
Yes.
Larry Kaplan.
Yes.
Jen Oyang.
Yes.
And Deirdre Robinson.
Yes.
Okay, with that, the motion carries. And the third item put forward by the committee?
It's, and for program measurements to allow for 1/5 increments as identified in the standards for all delivery methods, and to develop draft language for a future meeting at which time the CBA may direct staff to initiate the rulemaking process.
Great, thank you. With that, that becomes fully formed. No need for a first or a second, but we do now entertain member comments or questions regarding 1/5 hour increments for CE. Okay. And I think my only comment is, by this rule, am I correct in understanding that courses in any format could then use this 1/5 hour? So it could be
That's
a
correct.
half-hour class.
So whether it's a live
It's live.
program, self-study, or group internet, it would be allowed to have the 1/5 hour.
Okay, great. Thank you very much. Okay, in hearing and seeing no more additional questions from the board, I'd like to ask if there's any public comment to be made at this time. Okay, hearing and seeing no public comment, I'd like to call for the vote.
Deirdre Robinson.
Yes.
Katrina Salazar.
Yes.
Leslie Lamana.
Yes.
Mark Silverman.
Yes.
Larry Kaplan.
Yes.
Carrie Ann Farrell Hines.
Yes.
Soshi Leon.
Yes.
Jen Oyang.
Yes.
George Familet.
Yes.
Jose Campos.
Yes.
And Alicia Burhell.
Yes.
Okay, thank you, Ms. Reed. And with that, the motion carries. Do you like to go take that? Yeah, okay. Great.
Do you want me to wait for her to come back?
Yes, and we'll wait for our board member to return, and then if you, when she's ready, if you'll proceed with item 3.
All right, then, with that, the CPC also recommended that the CBA maintain status quo and take no action on the following continuing education requirements: live programs, self-study, program reporting requirements, and group internet-based programs.
Okay, all right.
All
So,
right. You want me to go ahead and go forward, or do you want to allow for
Please.
discussion?
Please.
I don't know if there's any discussion on this.
comments,
or-
questions?
Okay. Then the second area that we discussed was at the September 2016 meeting, the CPC discussed the administrative and enforcement aspect of the CPA's handling of criminal convictions involving drugs and alcohol. At the conclusion of the meeting, the CPC recommended to the CBA to have the Enforcement Program Oversight Committee consider changes to the CBA disciplinary guidelines to reduce the minimum penalty associated with criminal convictions to suspension, stayed, and 1-year probation. The EPOC considered this recommendation at its meeting this morning. The CPC does not believe that the CBA needs to evaluate any additional criminal convictions. This was an information item and no action was taken. And that concludes my report.
Thank you, Ms. Lamona. All right, so concluding the report of the CPC, the next committee up is the Enforcement Program Oversight Committee. So I'd like to invite Ms. Kathleen Wright as chair to present that report.
Thank you. First was a number 9B2, which was a revision schedule for the disciplinary guidelines and model orders. Staff provided an update on the changes to the schedule. There was no action required on this item. 9B3 was discussion and possible action regarding proposed changes to the disciplinary guidelines and model orders, and Title 16, California Code of Regulations, Section 99.1, rehabilitation criteria for denials, suspensions, revocations, restorations, reduction of penalty. Staff provided an overview of this item. Staff noted that the guidelines reflect various changes requested and adopted by the CBA over the past few meetings. Staff informed the committee that Cal CPA is no longer requesting that CBA consider possible revisions to the minimum penalty associated with Business and Professions Code Section 5100, Subdivision L at this time. EPOC spent the majority of the meeting discussing the CPC's recommendation to have the minimum penalty associated with violations of Business and Professions Code Section 5100 Subdivision A. The CPC had requested that the EPOC consider a reduction in the minimum penalty from revocation stayed, actual revocation of 120 days, and 3 years of probation to suspension stayed and 1 year of probation. EPOC heard from counsel regarding various concerns related to reducing the minimum penalty, including the ability to timely file a petition to revoke probation should it be warranted, the need to ensure that the CBA articulates the advancement of the public policy being achieved by any reduction, and that administrative law judges generally gravitate towards the minimum penalty. Members discussed various issues, including whether to limit the scope of the convictions for which the minimum penalties apply, specifically drugs and alcohol. Members also discussed concerns regarding whether the proposed decisions received from administrative law judges effectively weight the nature and the seriousness of the offense. After considerable discussion, the EPOC recommends that the CBA table action on this agenda item. The EPOC requested that staff report back regarding possibly narrowing the scope of offenses to which the reduction of minimum penalty applies, and to work with DCA legal counsel on how administrative law judges evaluate the nature and the seriousness of the offense. 9B4, discussion and input on the newly developed California Board of Accountancy Enforcement Handbook for licensees. Staff provided an overview of this item. Members requested that staff provide increased clarity on the tolling provision included in orders for probation and ensuring that licensees are aware of when enforcement documents are placed on the website. Members also requested that the Internal Revenue Service and the Franchise Tax Board be added to the list of complaints that the CBA receives and reviews, and to add a link to publicly available enforcement documents found on the CBA website. That concludes the report.
Okay, any questions, Mr. Campos?
Yes. The CPC clearly spent significant time deliberating on the issue that we referred over to the EPOC. As I listened to the deliberations, I frankly didn't understand why we could not just adopt within the guidelines any clarifier within there without making any further wholesale changes or research or what have you. I think it would have been fairly simple to indicate a minimum penalty designation that maybe bifurcates. I listened to Ms. Leon's comment during the EPOC deliberations of maybe we specify a certain minimum penalty that relates to drug and alcohol-related criminal offenses and maintain the existing minimum penalty for that area that relates to other criminal areas. Frankly, the other criminal areas have been fairly rare in terms of the kinds of things that we have seen in our disciplinary action. So I don't know that there's a heck of a lot of other research that really needs to happen around that, but it would be helpful, I think. I mean, I would hesitate to make any kind of motion here to adopt the guidelines without the EPOC going through a formal approval process, but I would suggest that maybe in the subsequent deliberation that just be a consideration that gets included in there. And then the second topic is, I listened to the discussion about ALJ activity. That is another place where I just feel that we rarely see ALJ items. We not rarely, we see maybe one or two per meeting. I don't personally think we have an issue with what we are getting from our ALJ environment, and I would hesitate to put something on our agenda that tries to deliberate on an issue that I don't think is a problem for the CBA. You know, so I worry about overreach and frankly the negative connotation that we're going to get by putting all of this deliberation on the record on something that I do not see as an issue for this board. So those were a couple friendly reactions to, I think, what we saw, coming from the EPOC deliberation process.
I second that motion.
There was no motion.
Thank you for your concurrence, Ms. Lamana.
Yeah, and what I do see more frequently than any problem, I can only remember like 2 cases in the 10 years I've been on the board that we sent back and said we disagree with this conclusion, and it was usually over some technical issue that it was sent back to the judge, and they, some incorrect spelling or something like that, and it was sent back. What I do think is a bigger issue is when we have these higher minimums, that's what ends up getting used, that whether it's the licensee's attorney or the licensee himself looking at that and saying, that's the minimum I can have. They agree to that, they stipulate to that, it comes before us, and we're hesitant to, after they've already gone through all the process and how long it takes to go through, to extend that process, to send it back and say, no, we're going to adopt it and then reduce it. I don't think they would object to having it reduced, but it has been, the board has always been hesitant to change those. That's what I've seen over time. It hasn't been frequent that we have said, let's reduce it, we'll adopt it and then reduce it. But I've heard many times, I can't agree, I can't understand why this person agreed to this because it's harsher than it should be for maybe an administrative item that we didn't agree with, or a 10-year-old DUI kind of thing that wasn't reported to us. So would be my concern in not reducing the handbook, and since we rely on that so heavily.
Additional comments?
I think it would be helpful to have a little bit of guidance from staff about the concerns that were expressed that compelled our committee to table this for additional discussion. So, there were 2 concerns particularly that were expressed around what authority our body has to change or change the recommended penalties that are imposed by administrative law judge's decision, and also there was an issue around, I guess an administrative issue around, sort of our jurisdiction, how our jurisdiction continues to apply, just to be sure that it's reflected that, we're not hesitating to act out of an overabundance of caution, but it really was compelled by staff's report and about their concerns on reducing those minimum penalties. I think that it would be helpful to share that with the broader body.
Christy?
So it was really your counsel, both your enforcement and in-house, which is kind of my role, counsel regarding reducing the penalty. As Mr. Campos has indicated, you don't get a lot of proposed decisions, so it's not really as big an issue. But one of the issues with proposed decisions is it's much easier to reduce a penalty on a proposed decision than it is to increase one. And so that's where one of my concerns was with starting with a low penalty. If an administrative law judge started with a low penalty you didn't agree with and you wanted to increase it, there'd be a 3 to 6 month additional time lag before any enforcement action would be taken while you're rewriting the decision to increase the penalty. Whereas if it starts high and you think it should be mitigated to a lower penalty, you can simply adopt the decision at that meeting and reduce the penalty right there. And that's a much quicker process. With settlement agreements, you have a lot of flexibility there, and not all of your decisions have to be voted on in person. So if you decided you wanted to make a counteroffer and in effect that decision before your next board meeting, you can always vote to look at the revised offer by way of email or mail ballot and adopt a lower penalty, that you've directed the staff to negotiate. So to me, there's really not a concern from a legal perspective regarding changing penalties that you think are too high in a settlement agreement. You have a lot of leeway with settlement negotiations to change the penalty, to mitigate the penalty, to alter the terms and conditions. And I know what you're talking about, concerned about undoing the work that's been done, but it's your will, it's your decision. And if you feel like that's not the appropriate penalty, whether up or down, it's your right to say, I'd like to counter that offer and make another offer. And then you could vote on it by mail if you're concerned about the time lag.
You know, my reaction to this is that this conversation has come as a result of trying to give our staff working for the board on the enforcement side more clarity about sort of how this body views the penalties that they're negotiating. And then are you able to comment on Mr. Campos's suggestion about maybe a bifurcated clarification minimum?
Sure.
Where if the will of the board was to say a certain
type of crime
would be viewed differently than others, I mean, could we put that in there?
Sure. I mean, we'd have to bring text back to another meeting to review that so the board could vote on the text in front of them. But again, we would need to explain why we're making the distinction. You know, potentially some types of crimes don't require as much investigation as others. That could be an explanation. But we would need something from staff to explain, you know, the workload issue, the impact. Because one of my other concerns that we discussed was that 1 year is typically too short a time to conduct an investigation for violation probations and make sure that we get the accusation or the petition to revoke probation filed before the time lapses. Because once the time runs on probation, if you haven't filed the accusation or petition to revoke probation, you lose jurisdiction over that violation because it's not unprofessional conduct to violate probation. So the probation order is the only thing that's keeping that person from being unrestricted in their practice. So that's one of the concerns that Mr. Sani and I raised with respect to your enforcement program.
I would just contribute to that part of the justification for why it changed is 2 years of deliberation on this board already about specifically drugs and alcohol related offenses and the conclusions and in some cases rejections of discipline that was being proposed because they were viewed as unfair. Okay, and so that has been deliberated on for some period of time now, and that's what gave rise to here. Maybe a fault that we had on the CPC in terms of the recommendation we made is that we should have made it specific to that item because I heard the angst with respect to other crimes that are potentially more serious and might have a different connotation, and hence the suggestion at the outset, let's bifurcate that within the guidelines. I think there are guidelines that the ALJs then would at least have something there for the few proposed decisions that we get, that at least they would have that at their disposal. The stipulated settlements, frankly, I agree with the flexibility, and I agree that this dialogue many times informs that process and the way that we approach it. And I heard all the discussion about the 1 year probation, but if we think the things that we've deliberated on for a couple years that we think this extreme was too extreme, I don't share the view that 1 year is not the right answer. I mean, hence the reason we came with that suggestion previously.
Ms. Wright?
I would add to Jose's comments that licensees are also members of the public whose rights need to be protected. And to give them 3-year probation when 1 year probation is probably a remedy that correlates more closely with the level of the offense, at least as it relates to the practice of accounting, is the top consideration.
The top consideration with respect is public protection. So we have to make sure that when we ever make a decision that we come from that perspective. So if you're saying that we can still protect the public with a shorter penalty, then that would be totally defensible to write that in terms of a rulemaking. But I would caution you against making the justification based on fairness to the licensee without considering the effect on the public.
Okay, is there a comment over here, Ms. Lamanna?
Well, I was just going to say, in light of the Little Hoover report, where they're also looking at people that past offenders, and fairness to them, and that boards should be addressing this. I think we have to look at the common sense of our enforcement division and ALJs, that they're going to say, well, if someone committed murder, that's something maybe more significant than someone that has a sex offense, and they should take that into consideration in applying these rules. I think they will. And I don't see it as that we need to separate it. I think you have to assume there's some common sense there and people will apply these correctly.
Right, which is why I asked Mr. Sani to come forward, because I wanted you to make sure you understood the benefit of our experience has been that they don't necessarily do that. They tend to follow the minimum unless there is something more egregious, and then they go to more towards the revocation realm. So that's been our experience. We wanted to share that with you.
Separating out, going through the whole criminal code and separating out each crime and say...
Right. But I think we were looking at, as Mr. Campos pointed out, the areas of that you most bothered the membership with respect to the way the crimes were being evaluated. So I think that there would be the legal authority to do some sort of separation if that is what the will of the board was.
Mr. Campos, do you have a comment?
It sounds like we've got enough dialogue to inform the next epoch deliberation.
So let me ask for some clarity. Is a tabled motion, does it require any action on our part?
Not typically, because that's the committee's decision to move it to another agenda.
Would it be appropriate, we've received members'
Accept the
comments?
report, though.
So, well, I was going to say to open up to public comment in case there is any. We do have some stakeholders in the room. Is there any public comment on the issue? Hearing and seeing none, then I would like to thank Ms. Lamanna for the report and accept it into the record. Oh, I'm sorry, Ms. Wright, I'm sorry.
That's absolutely
That was
okay.
that was the previous report. Thank you, Ms. Wright. All right. Let me see where we are in our agenda. I got so wrapped up in that when I flipped the page over. Okay, so does that conclude the Enforcement Program Oversight Committee? I believe that does. And then we now move on to the next committee, which I believe, if I'm not mistaken, is the Legislative Committee. And so I'd like to invite Ms. Deirdre Robinson, Committee Chair, to present.
Thank you. Staff reported that at its March 2016 meeting, the CBA reviewed several comments received during the public comment period of the rulemaking related to credential evaluation services. Most of the comments were rejected because the requested change needed to be made in statute, not regulation. The CBA directed staff to review the rejected comments and recommend whether possible legislative action should be taken. During today's Legislative Committee meeting, staff provided a summary of each comment rejected in the rulemaking process, followed by a recommendation whether to propose language to inclusion in the Senate Business and Professions Committee Annual Omnibus Bill. The Legislative Committee recommends that the CBA adopt the proposed changes to the Business and Professions Code Section 5094D as identified in the attachment and direct staff to seek its inclusion in a 2017 omnibus bill, or if necessary, seek an author to carry a separate bill.
Okay, thank you
That
to the
concludes the
committee for that
report.
motion. So it comes forward as a fully formed motion, so we do not need a first or a second, but we do need to open up to member comment and question. Okay, hearing and seeing none. Public comment, do we have any public commentary? All right, hearing and seeing none, I'd like to please call for the vote.
Okay, Mark Silverman,
Yes.
Kathleen Wright,
Yes.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Soshi Leon,
Yes.
Leslie Lamana,
Yes.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familar,
Yes.
Carrie Ann Farrell Hines. Okay, and Larry Kaplan,
Yes.
and Jen Oyang.
So I believe with that, the motion still carries. And were there any closing items, Ms. Robinson? Any other items to report on?
No. That
Okay.
concluded the report.
Thank you very much for that committee report. That moves us along to the next item, which is the Mobility Stakeholder Group. So I'd like to introduce Mr. Jose Campos, the committee chair.
Item 9D3, regarding timeline of activities. We had an overview of the CBA-approved assessment process, which falls in line with the timeline set forth by the statute. Staff reported that Phase 2 is no longer required. Therefore, the timeline has been revised to remove all references to Phase 2. With that, the MSG recommends that the CBA adopt the revised timeline.
Okay, thank you for that motion. Are there any member comments before we proceed? Are there any public comments about the motion to adopt the proposed timeline? Okay, hearing and seeing none, I'd like to call for the vote.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familar,
Yes.
Carrie Ann Farrell Hines, Larry Kaplan,
Yes.
Leslie Lamana,
Yes.
Kathleen Wright,
Yes.
Mark Silverman,
Yes.
Katrina Salazar,
Yes.
Deidre Robinson,
Yes.
Soshi Leon,
Yes.
Jen Oyang.
All right, thank you. With that, the motion carries. And
Item 94, assessment of Georgia and Utah. Staff reported at the September 2016 meeting that the CBA directed staff to conduct the assessment of NASBA's findings regarding Georgia and Utah's enforcement programs. On October 4th, 2016, via Skype, staff conducted this assessment using the same method as with the previous two assessments, which included NASBA providing staff a summary of the specific enforcement practices and staff asking one random question from each section of the state information sheet to validate NASBA's data. Based on the results of the assessment and the verification of the availability of disciplinary information on the internet, staff were satisfied with NASBA's identification of Georgia and Utah as being substantially equivalent. There was an inquiry about staff's access to NASBA's raw information during the assessment. Staff reported that in all three assessments, staff had the opportunity to see the raw information if it was not satisfied with NASBA's answer to a question chosen at random to validate the data. Staff stated that they followed the CBA-approved process during each assessment. I stated that the framework that the MSG established, which the CBA adopted, provided flexibility in the extent of inquiry and review of evidence required, and that staff used this with each assessment. This was an information item for the committee. Next item is item 95, discussion and possible action regarding next steps for making determinations pursuant to Business Code Section 5096.21A through B. Staff reported that NASBA currently identifies 45 jurisdictions as substantially equivalent, with only 10 states having been identified as substantially equivalent, but without a disciplinary flag on the internet. No jurisdictions at this time remain undetermined. Staff is continuing its work with the 10 states to post their disciplinary information on the internet by the end of 2017, which was echoed by Ed Jolliker's comments earlier. The MSG recommends that the CBA determine Alaska, Delaware, District of Columbia, Georgia, Maine, Mississippi, New Mexico, Utah, and West Virginia to be substantially equivalent to NASBA's guiding principles of enforcement.
Okay, thank you. With that, that is a fully formed motion, and we are now ready to move on to member comments and questions. The motion at hand. Okay. Hearing and seeing none, I do want to open the floor to any public comment regarding the recognition of additional states as substantially equivalent. Okay, hearing and seeing none, I'd like to call for the vote.
Kathleen Wright,
Yes.
Mark Silverman,
Yes.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Jin Oyang,
Yes.
Soshi Leon,
Yes.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familet,
Yes.
Carrie Ann Farrell Hines,
Yes.
Larry Kaplan, and Leslie Lamana.
Yes.
Okay, thank you. With that, the motion carries.
Item, says 8C6, but I think it was 9C6, 9D6. Our draft mobility stakeholder group report. The item allowed the MSG an opportunity to discuss and propose changes to the draft MSG 2016 annual report. The report describes the actions and activities that the MSG has undertaken in 2016 to ensure compliance with California's practice privilege law. Highlights from the report include the MSG directed 3 rounds of state assessments totaling 15% of all states, and the MSG recommended and approved 36 states at that time, 45 after the motion that just got adopted, as substantially equivalent to NASBA's guiding principles of enforcement. The MSG directed staff to add more detail regarding the methodology and process of assessing NASBA's substantially equivalent results in order to be prepared to respond to potential questions from the legislature. Staff will present the final version of the report at the next meeting in January, and that particular item was an informational item. Next item 7 relates to CPA Verify. Received a report that 51 jurisdictions currently use ALD and CPA Verify, with 4 states, Delaware, Hawaii, Utah, and Wisconsin, not yet on there, but being worked through. Again, that was informational. Last item 8 was agenda topics for the next meeting, which will include a further review of any additional states identified by NASBA as substantially equivalent by way of having adopted some kind of internet flag, and then a review of the annual report update. That was the last item.
Thank you very much for that committee report, Mr. Campos. That concludes item number 9, and we move along to 10, which is the acceptance of the minutes. And we do have 5 different minutes. The minutes of the September 15-16 Board of Accountancy meeting, September 15th CPC meeting, Enforcement Program Oversight Committee meeting, Mobility Stakeholder Group meeting, as well as the July 27th Qualifications Committee meeting. I'd like to make a motion to approve those.
I move approval of items A through A.
Jose has the
through E.
first, Mr. Silverman has the second. Member comments? Any corrections, edits? All right, hearing and seeing no comments, I'd like to ask if there is any public comment on the minutes. Okay, hearing and seeing none, I'd like to call for the vote.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Familet,
Yes.
Carrie Ann Farrell Hines.
Yes.
Larry Kaplan,
Yes.
Leslie Lamana,
Yes.
Soshi Leon,
Abstain.
Jin Oyang,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar,
Yes.
Mark Silverman,
Yes.
and Kathleen Wright.
Yes.
Okay, wonderful. With that, the motion carries. The next item is 11, which is other business. So we have 2 reports. The first is from the American Institute of CPAs, and the second is from NASBA. It's my understanding that we don't have any reports coming forth from the audience. And seeing no movement, I believe that is true. So since there are no reports, we will move along to item number 12, which is the officer elections. Each year, the California Board of Accountancy selects a CBA president, vice president, and a secretary/treasurer to serve in a leadership position. And what I'll do now is kind of talk about the process that we'll go through. So these elections are held in a very specific order. The first election is the secretary-treasurer position, then followed by the vice president and president. So we do have attachments in the documents that are available online and in front of our board members present, which are statements of qualifications from CBA members seeking to serve as an officer. So prior to the leadership position vote, members who have not previously submitted a statement of qualifications will have an opportunity to express interest in a position, and all candidates will be given up to 5 minutes of floor time to describe why they are qualified for the position. Once all candidates are identified for a position and they have been provided the opportunity to address the board, a vote will be taken for each candidate starting in alphabetical order by the candidate's last name. The first nominee to receive a majority vote will win the officer position, and the newly elected president, vice president, and secretary-treasurer will assume their respective offices at the conclusion of the meeting and will serve one-year terms. So since the mailing of the meeting materials in your binders, no members have expressed interest in serving as the secretary-treasurer. I would like to open the floor to see if any members would like to serve in this position, and candidates will be given up to 5 minutes of floor time to describe why they are qualified. So, and we'll take that. If there are more than 1 or 2 or 3 folks step forward, we will listen to the 5 minutes each, and then we will vote alphabetically by the candidate's last name, starting with A through Z. That would be alphabetical order. So at this point, I would like to put forward to the board members and ask whether or not there are any members who have interest in serving as secretary-treasurer. So I'm gonna fill this. Oh, sorry, yes.
I'll volunteer. Is that what the response is you would like?
So we have 1 interested member. The process is we call for a motion and a second, and we would proceed to see that process until we determine all interested parties in the room. So we have a volunteer, which is Ms. Wright, and so now we need a first and a second. Can Ms. Wright be her own first?
She can be her own first.
She's her own first, so what we need is a second.
A second.
Okay, so we have a second from Ms. Farrell Hines. Are there any other parties interested in the secretary-treasurer position for 2017?
Then you can just call for the vote if there's no.
Okay, well, we have Mr. Silverman. Am I correct that you're throwing your hat into the ring?
That's correct.
Okay, so Mr. Silverman puts forth a motion to be considered, and we need a second.
Second.
Okay, so Ms. Burhow has seconded the motion. So at this point, we have 2 candidates. Anyone else? Okay, seeing none, I believe we're going to close that at 2 candidates, which are Ms. Wright and Mr. Silverman. I would like to, we'll go in alphabetical order. Mr. Silverman, would you like to spend a few moments to make a brief statement? You have up to 5 minutes.
I don't need 5 minutes. I'm happy to take 1 or 2. The board knows me, but not everybody in the public knows me.
Could you
Sure.
pull the microphone?
I'm an attorney by training, but don't practice law. I'm an angel investor and oftentimes executive at some of the companies I invest in. I've been in the regulatory area of the law many moons ago at the Federal Trade Commission, and I'm very interested in serving the board where I can help.
Okay, thank you very much. Ms. Wright, would you like to make a statement as well? You have up to 5 minutes.
Sure, thank you. I'm a CPA and a lawyer, and I have been working in the field of tax for 45 years, and in pretty much every aspect of the field of tax, from public accounting to education, publishing with the agencies, at least as a sabbatical with the Franchise Tax Board. The bottom line is, 1, I've been on the board for 1.5 years. 2, I have observed and noticed how, 1, efficiently it works, and I'd like to continue to promote that efficiency in the context of an officer position. And secondly, to the extent that there are certain small areas here and there that can be tweaked and perhaps improved, I think that's the responsibility of all of us that serve on the board, and to have to be in a position in order to implement improvements here and there where they may be appropriate is a desire and goal that I've had ever since I came on the board. So thank you.
All right, thank you. So that concludes the second candidate statement. At this point, as I read previously, the vote will be taken for each candidate starting in alphabetical order, and the first nominee to receive a majority vote will win the officer position. So that first would be Mr. Silverman, And I believe we do it by a standard vote. Roll call vote. Ms. Reed?
Leslie Lamana,
Yes.
Soshi Leon,
Yes.
Jen Oying,
Yes.
Deirdre Robinson,
Yes.
Katrina Salazar,
Yes.
Mark Silverman,
Yes.
Kathleen Wright,
Yeah, what did we, I'm sorry, I'm a little confused. I'm confused. I thought we did it by show of hands last time.
I think the rules changed on our voting. I mean,
Well,
the-
you've selected in the process to do all your motions by way of roll call vote. That was
Yes.
the process you selected, I think, a year ago.
Oh, okay.
Because by
what
law, we
changed.
have to record the vote of every board member at a meeting for every minutes, all the minutes we do. So if you don't agree with the person being nominated, you should vote to
No,
oppose.
I'll agree. I'll agree.
Larry Kaplan,
Yes.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Pamela,
Yes.
Carrie Ann Farrell Hines.
Yes.
Okay, so with that, the motion carries, and Mr. Silverman then is elected as secretary/treasurer. And then we move along to the vice president, and that position has been submitted with a statement of qualifications by Mr. Michael Savoy for the position of vice president. So we do have... Who? Mr. Savoy. Yeah. In his absence, no, I am required in all cases to open the floor, just as we did previously, and see if any additional members would like to serve in this position. And the process follows the same one as we just did for the last election. Do we have any additional candidates interested in this position of vice president? All right, hearing and seeing none, we then have to call the roll for a vote for Mr. Savoy.
So we need a motion and a second to nominate
Oh,
him
I'm
first.
sorry.
I move to nominate Mr. Savoy for vice president.
Mr. Campos is the first, and Mr. Silverman is the second. So member comments? Public comment? Moving along, I'd like to call for the vote.
All right. Larry Kaplan,
Yes.
Carrie Ann Farrell Hines.
Yes.
George Pamela,
Yes.
Jose Campos,
Yes.
Alicia Burhow,
Yes.
Leslie Lamana,
Yes.
Soshi Leon,
Yes.
Jen Oying,
Yes.
Kathleen Wright,
Yes.
Mark Silverman,
Yes.
Katrina Salazar,
Yes.
and Deirdre Robinson.
Yes.
Okay, with that, the motion carries, and Mr. Savoy has been elected to the vice president position. At this time, we move along to the final election, which is president, and Ms. Alicia Burhow has submitted a statement of qualifications for that position that is included in your materials. Just as we did in the last two votes or elections, I would like to open the floor and see if any additional members would like to serve in this position. All right, hearing and seeing none, I will call for a motion and a second.
I'd like to make the motion to nominate Ms. Burhow.
Okay, we have a first from Ms. Lamana. Do I have a second? And a second from Mr. Silverman. Member comment, public comment, call for the vote.
Okay, Kathleen Wright,
Yes.
Mark Silverman,
Yes.
Alicia Burhow,
Yes.
Jose Campos,
Yes.
George Pamela,
Yes.
Carrie Ann Farrell Hines,
Yes.
Larry Kaplan,
Yes.
Katrina Salazar,
Yes.
Deirdre Robinson,
Yes.
Jen Oying, Soshi Leon,
Yes.
Leslie Lamana.
Yes.
Okay, with that, the motion carries, and congratulations. The president for 2017 will be Ms. Alicia Burhow.
Thank you. Point of clarification,
Yes.
can we give Mr. Savoy some additional responsibilities?
In his absence?
I think he's watching. He is watching. So we should, yeah. So can we give him some more responsibilities in his absence?
believe that would be under new business. No. So moving along to item number 13, which is the closing business, and I'd like to invite any additional public comment. And we do have someone. Hello, we'd like to welcome Mr. Jason Fox.
Hi, just very briefly, Jason Fox with the California Society of CPAs, and just want to... Louder, closer. There we go. I just want to congratulate the new officers for the election, and then I also want to recognize President Katrina Salazar for a great year. I think it's been an eventful year, and I think you've done a great job. And I also want to recognize Leslie Lamana. I believe this will be your last meeting on the Board of Accountancy. And so I just want to put in the record that we appreciate your service to the CPA profession, and thank you.
Hear, hear. Thank you for Jason making that comment. The next item, which is 13B, is the agenda items for future California Board of Accountancy meetings. And I'd like to kick that one off with reiterating the request that our QC chair, Ms. Jenny Bolsky, brought to the table, which is to address any needed revisions to the certificate of attest experience and do that in a more formal environment. So were there any other additions to future agendas, Ms. Wright?
The AICPA and I think NASBA, I'm not sure, have come out with either one, a white paper and/or two recommendations for boards of accountancy to consider regarding the legalization of marijuana and what a CPA's role and interaction with the client should be related to that very controversial issue. I bring it up now because, as you're probably aware, in the November election, California did, Proposition 64 passed, and California did legalize marijuana for recreational use, which implies that this business segment is going to become more popular, and more clients of CPAs are going to be interested in getting into, quote, this profession. And so I'd like to ask that our board consider the AICPA guidelines for adoption regarding this issue.
Okay, so we have that request, and it's noted then for a future agenda item to be incorporated and evaluated by staff. Any other items? All right. So hearing and seeing no additional comments, at this point we're ready to move into closed session, which will be item number 14, and I do need to read what that is for. We will be doing multiple things. Let me go backwards here. We have the first item will be a meeting in closed session pursuant to Government Code Section 11126A1 to conduct an annual evaluation of the executive officer. And then we will also move into pursuant to Government Code Section 11126C3. The board will convene to deliberate on disciplinary matters, which include stipulated settlements, default decisions, and proposed decisions. And the final item to be addressed during closed session is our advice from legal counsel on litigation related to Greenberg versus Board of Accountancy, LA Superior Court, case number BS 15045. So before we do recess for this closed session, again, I'd like to thank my board members as well as those in the audience who participated. And with that, we are recessed into closed session.